Yesterday my lord was pleased to allow my mentioning
Yes.
regarding 102. Yesterday it was 102.
102.
Today it is 103, my lord.
Today it's 103.
My lord.
All right, inform the other side, it will be taken up tomorrow.
Tomorrow, my lord. Deep your pleasure.
My lord.
Yes.
My lord, under extreme compelling circumstances, I'm mentioning a few matters for accreditation, but same matters, my lord. But what has happened, plaintiff petitioner had obtained an order of injunction. Thereafter, they had filed an application for police help. On the first day, it was ordered that we will give objection. Against that order, they had come up before this honorable court. Ex parte moved, an injunction passed. Therefore, my lord, something has gone down. The mediator appointed, mediation failed. There is no interim order. My lord, small prayer sent down for hearing the injunction along with the.
So why did you not mention yesterday?
Yesterday I missed, my lord. It is 892 to 897 of the list. Same matters, my lord.
Please mention the urgency, hand over the slip.
Have I mentioned the urgency, my lord? It's a 1 minute matter, my lord. It will have to be remanded back for.
All matters.
I understand, my lord. I am
1 minute for you.
I understand, my lord.
But it takes time for the court to understand.
It is only time.
Yes.
Well, could I mention, my lord, of course, my lord, I stand on the same footing as that of Mr. Lahiri. But, my lord, there are 3 227 applications, my lord, primarily, my lord, on the issue of, my lord, disposal of, my lord, appeals, my lord, under the PP Act. My lord, the statute provides for a time limit for disposing of, my lord, this remain pending for years together, my lord.
Advocate General, many statutes prescribe time limits within which proceedings under those statutes have to be, even under the Premises Tenancy Act.
Right. But some, my lord, observations of expedition.
Who is opposing you?
Lord, we have served notice. We have served notice. Kindly keep it on a day convenient. I don't think it will take much time. There are 3 analogous.
Any urgency has been indicated there. Please ask your.
But the urgency is what I have said. That
please ask your juniors to put in the urgency and hand over the slip.
Slip
down, hand over করবেন নিয়ে নেবেন
urgency টা পরে লিখে
লিখে দিয়ে দেবেন
ঠিক আছে ও আচ্ছা urgency is there.
Lordship, may I have your lordship kind leave to mention one matter? Lordship, the date of execution is fixed before the landed court bill on 28th April. Kindly.
Execution at what stage? What is the order passed in the execution case?
Lordship, the order passed that the matter was pending before the honorable.
What is the order passed in the execution case for verification?
For verification.
Then
kindly take up
no urgency. Yes.
Lordship, you have permitted to mention for upgradation one contempt application. He was.
I did not mention yesterday. Mention next week. Yes. Call the list.
One, but I appeal for the opposite party.
Why it is appearing?
So this matter appeared, my lord, because of your lordship granted a stay for a particular limited while disposing of, my lord, but unfortunately that did not go in the order.
Can you tell me till which date I passed an order of stay?
Lord, till 17th of April, my lord, your lordship had granted the stay.
Yes, till 17th of April.
17th of that has to be incorporated.
Yes, well, that was.
But that now has expired.
But still,
so, yes. It has been uniformly submitted by the land.
My lord, I am appearing for the petition. It is a contempt application where the rule was issued, my lord.
Yes. Yes, Mr. Government Pleader, have you asked your?
Yes, my lord. My lord,
Uh,
according to him, my lord, it was a mistake that he had a mistake of the date, my lord. That is what he says. My lord, I've called him. He'll come at 2 p.m. to my office, my lord. I'll just take him.
Please,
I'll take him to task, my lord.
it's not a solitary matter, maybe.
No, my lord, absolutely not.
So please see that.
I'm not going to leave him. I'm also not going to leave him, my lord. This is not done.
Because the court's orders are to be taken seriously.
Absolutely, my lord, he has tendered his apology saying that it was his mistake. I want to understand what kind of mistake is this. My lord, if we don't uphold the dignity, my lord, then nothing will prevail. My lord, I never defend a contemner or any other person in default, my lord.
So the alleged contemner has been produced.
My lord, here she is, my lord.
Yes. She is represented by anyone. No.
Pradhan,
I am representing, my lord. The thing is that so far my instruction is that he.
Yes, Learned Government Pleader, you may leave now.
I am grateful, my lord.
Ask your junior.
While the writ petition was filed, she was not the Pradhan at that point of time. Subsequently, she was the Pradhan. My lord, I pray before your lordship, kindly direct my landlord to give a copy of the writ petition. And within 10 days, I will comply the order. Because no, there is no copy from the point.
All right. Pursuant both as well as the designation. You can understand why. দুজনের নাম। Yes.
I am for the contempt matter.
I am for the petition.
Yes, Mr. Bhuj.
Lordship, order has been already complied with.
Has been complied with. It has been submitted by the learned advocate. And the rule stands discharged. Rule issue হয়েছিল। Rule stands discharged. Yes, next.
Your Lordship, I'm
What is
going
that?
for a short password. My senior, Mr. Krishnadas Poddar is just coming.
Well, that matter I have to file undertaking. My lords, the parties have arrived at a settlement by
So tomorrow,
my lords,
Short password.
today, my lords.
today,
Yes, my lord. The parties have already arrived at a settlement.
all right, pass over next.
Great.
Five, Your Lordship, I'm for the opposite party, 5 and 6. Mr. Gopal,
Pass over. 5 and 6 pass over next.
Seven.
Well, this has come up at my instance for extension of interim order.
Who is appearing for the other side?
But I have served, but it seems they have lost interest.
They have?
It seems they have lost interest.
They have lost interest. Why?
The advocate refuses to accept service. I sent by email, I've sent to the client directly.
What is this matter about?
The business teacher of Christian minority school against the order of dismissal preferred an appeal, internal appeal.
Oh, order 7, rule 11.
7, 7. Okay.
All right. So this matter has appeared for extension of
already in the list.
It's already in the list.
The monthly list, it's running.
Oh, তাহলে let the matter retain its position in the list করুন। তাহলে ওইটা to appear in the monthly list না করে let the matter retain its position. Yes, call the next matter.
8.
Yes.
Wait, please.
Huh?
The petitioner preferred this revision application, madam. Madam, the petitioner preferred this revision application, madam, being aggrieved by and dissatisfied with the order, madam.
Yes.
They are rejecting the application under order 39 rule 1 and 2, along with an application under order 39 rule 7, madam. Madam,
Order 39 rule 1 and 2 is an appellable order. How can we challenge that to 27?
Lordship, I'm not agreed by order 39 1 and 2.
So, yes.
Madam, I'm agreed by order 39 rule 7, madam.
Yes.
Madam, what happened, madam? This petitioner, madam, is running a computer center in, madam, the scheduled premises. And, madam, this from 2004 onward. Here, madam, the petitioner filed this suit, madam, praying for suit for declaration, injunction, and adverse position.
What is the declaration for?
Declaration for adverse position. She's claiming adverse position for last.
Claiming title,
right title interest for adverse position.
Why local inspection? What for?
Madam, this petitioner is running, madam, this computer training center from 2004 onward. Madam,
Let him run.
Madam,
Why local inspection?
madam, because, madam, this petitioner, madam, the respondent private opposite parties, madam, are trying to disturb the ingress and ingress of the petitioner's local students, madam.
Show me your application.
Madam,
Order 39 rule 7.
Madam, madam, my application is in page 48 of, madam.
This is nothing but to fish out evidence. Also,
Lordship will kindly appreciate one thing, madam.
of the Yes, who is appearing? Appears for the petitioner.
Lord, Mr. Tilok Mitra is appearing on behalf of the petitioner, but his mother is ill, my lord. The Lord kindly keep it next week, my lord. And
What do you say?
mother is ill, my lord.
7172 filed belatedly, section 5 rejected.
On the prayer of the learned advocate for the petitioner, hearing appeal stands adjourned. Next. You can proceed. Yes.
Your Lordship, I'm for the petitioner. I'm praying for a very short Passover. My senior is engaged in courtroom number 34.
Passover next.
Yes, Your Lordship.
My lord. I think for both parties is here.
Yes, yes, please wait. Yes, 12. Yes, who is appearing? None appears for the.
Martin. Look, I'm praying for leave to appear through online mode, my lord. My lord, petitioner is a patta holder, my lord, who has purchased property from another patta holder. As per provisions, as per section 49 of the West Bengal Land Reform Act, this property has distributed with amongst the refugee person, my lord. And petitioner is a refugee who has come after independence, and he has purchased property from another refugee, my lord, and patta holder. And my lord, one preemption case has started, and in order number 12, my lord, so-cause has passed against your petitioner for expati injunction hearing, my lord.
Yes.
My lord,
Yes.
in property, my lord, this property is a freehold property, my lord. This property
Has been directed. Reply to the show cause. Please reply to the show cause. This application under Article 227 is at the instance of the plaintiff and is directed against the is at the instance of the opposite party in a preemption application and is directed against an order number 12 dated 17th of January 2025 passed by the Learned Civil Judge Junior Division Second Court at Bakura in J Miss within bracket preemption PRE bracket close number 10 of 2024. First up, by the order impugned, the petitioner herein was directed to file reply to the show cause. Full stop. The learned advocate appearing for the petitioner submits that the suit property is a refugee property. And
freehold property.
Yes.
Freehold refugee property, my lord.
Refugee property.
Yes, freehold
Yes.
property, my lord.
No, I could not follow you. Is a
My lord, freehold property, my lord.
not a refugee property.
Yes, but it has distributed amongst refugees, my lord.
Is a refugee property, and therefore the application under Section 8 of the West Bengal Land Reforms Act is not maintainable. Full stop. However, from the impugned order, this court finds that since the petitioner was not present, in spite of repeated calls on 17th of January 2025, the petitioner's hearing was directed to give reply to the show cause. Full stop. For such reason, this court does not find any infirmity in the impugned order. It will be well open to the petitioner to file the reply to the show cause as directed by the order impugned. If such reply to the show cause is filed, the learned trial judge shall consider the same in accordance with law and pass necessary orders. With the above observations and directions, CO number Sajanta stands disposed of. Yes, call the next matter.
12 has been dismissed. I am here. I could not follow. 12. I was here, Lord.
What has been done?
Dismissed, Lord. Also, can
It is for default. File an application, Mr. Ghosh.
Lord, can here. Here.
12th.
I was here.
Yes.
Lord, in a suit for specific performance of contract, Lord, initially, Lord, the original defendant,
But the,
I am for the plaintiff.
yes, suit for specific performance of
Yes.
contract.
Lord,
What is the impugned order?
Lord, impugned order, Lord, the suit was decreed
Suit was decreed.
and an appeal was preferred by the defendants, added defendants.
Added defendants.
Yes.
Yes.
During appeal, Lord, one of the defendants died. They failed to,
During appeal, one of the defendants died. Yes.
they filed an application for substitution of setting aside amendment after condonation of delay. And a case was registered. It was dismissed by the learned appellate court. A revisional application was preferred. The revisional court says that one of the heirs was already there, therefore it was not abated. He remanded the case back. And during hearing of the civil division case, Lord, it was found that the defendant number 10, one of the added defendants, he died before passing of the degree. Therefore, the appeal court was directed to allow this substitution application, Lord, for which it was found to be abated. That was done, and there was a direction the plaintiff.
No, I could not follow. The appellate court found that the defendant, added defendant number 10 died.
No, before that, Lord, appellate court, before the appellate court,
yes,
the appellate filed an application for setting aside abatement after condonation of delay in respect of some other
parties. That was done.
That was not done.
Now
That was rejected. In revision, it was directed that as one of the heirs are already on record.
There is no question of abatement, so the heirs are to be brought in.
Here
So that chapter is closed.
And it was found by the revisional court itself, at the revisional court, that one of the defendants, the added defendants, they died before passing of the degree.
Then decree is nullity, Mr. Ghosh.
That's why, my lord, he directed the appellate court that after that substitution is allowed, the plaintiff may be given a chance so that he can make an application before the trial court for substitution of the heir of defendant number 10.
Yes.
Accordingly, my lord, matter was demanded. And application was made for substitution, it was allowed.
Before the trial court?
Before the trial.
Application was filed.
Right.
It was allowed.
Yes.
Now what happened?
But thereafter, the plaintiffs filed an application that as the substitution application has been allowed, degree may be amended.
Cannot be done, Mr. Ghosh.
Otherwise, not the
decree. How can the decree be amended only? Abatement, so it requires, because that decree goes. Mr. Ghosh, that decree goes. It has to be again reheard.
Again, the
because Mr. Ghosh, what is the object of why it is nullity? Because the heirs of the deceased party did not get any opportunity to contest. So the not only decree cannot be corrected in that way. Entire judgment and decree goes, it has to be reheard. It has to start from the state after setting aside abatement.
Lord, the same set of defendants were jointly filed.
The 470 Calcutta, page 99.
That Lord, here kindly see not cases.
So it cannot be rectified, Mr. It's not a case of amendment of the decree.
Some extent, Lord, it is there. They jointly filed it statement, jointly contested.
The Ghosh, maybe
same interest.
That is not the issue. But if it's a decree, is a nullity if it is passed against a dead person.
But the appeal court initially
several judgments, also full bench judgment.
I know,
and 70 Calcutta is squarely on that point.
But here they jointly contested the matter.
So that has been rejected.
That has
amendment rightly rejected, Mr. Ghosh.
Lord, kindly see that again, Lord, the
has to be
same evidence. No further evidence would be
added. That is a different thing, but only the decree correction will not help, because he has to be given an opportunity, arguments, whether fresh evidence is necessary or not. That is, I cannot decide from here, because if that defendant wants to lead any evidence, or that defendant is no more there, the substituted heirs has a right to lead evidence. If they want to give any evidence.
Only one written statement jointly filed and they will not reduce evidence.
Mr. Ghosh, I appreciate that, but entire decree goes. It's not the decree. See, though we say that the decree is a nullity, so what is the decree? So entire judgment goes. 70 Calcutta, Mr. Ghosh, you are aware of this.
But in view of this fact, I was placing the matter that the joint written statement, they jointly adduced evidence and degree was passed on contest. Therefore,
show me the reasoning, it's right.
Lord, kindly see this. 13th March 2025, the order. Last next.
Yes, though not in so many words, but
Here, can you see the appeal was disposed of after setting aside the degree first by this court. This court is now the appellate court has taken a view that degree.
now the suit is pending, Mr. Ghosh.
Huh?
Suit is pending.
Suit is pending, Lord, after if the degree is set aside. The appeal court will finally see the first order.
Now the substitution setting aside abatement has been set aside.
Yes.
So now I'm directing the trial court to proceed in accordance with law.
Your lordship kindly see the appeal court what read. Your lordship kindly come to the appeal court's order. That is, Lord, order number 120.
120.
120.
Yes. Which page, Mr. Ghosh? I've got 121. Order number 121 I've got.
That 120 is another order. I'm saying.
Where is 120? Which page?
Yes, Lord, that is at page. This is not resignation. After the order of this Lord revisional court, just key. Lord, before the application 151, the 152 application. That is, Lord,
Oh, Mr. Ghosh, I find that in the earlier round of litigation, 70 Calcutta was referred to.
Yes.
In the civil revision application.
Referred to and Lord, kindly see the what is the direction of the revisional court. And Lord, the
what was the direction?
Kindly see, Lord, the direction I have annexed the order. Yes.
Yes, on perusal of the aforementioned judgment, the division bench, this court has got no hesitation to hold that when it is brought to the notice of the first judge that practically an effective duty has been assailed, it would be the duty of the first judge to set and to remand the matter. Yes.
And then,
rightly done.
And then, Lord, kindly see the next order, next page.
Yes.
After this order, 120.
Consequently, the impugned order number passed in title appeal was set aside. What was the order passed in the title appeal?
Well, that is amendment was recorded that substitution application was rejected.
Oh, is set aside, directed to act. Set aside the first is directed to act in accordance with the law, keeping in mind the observation. So it was had to be remanded. That has been done after that.
And well, thereafter, after remand, what was the order? Can you see? Next
After,
page. Next page.
Next page, 120.
Yes.
Yes. So you are directed to take steps for substitution.
Yes.
So but you have not taken steps for substitution.
Yes.
You have only paid for amendment of the degree. How that can be done, Mr. Ghosh?
That was allowed.
Where is that order? Allowing the substitution after setting aside abatement? Because the abatement has set in.
No, it was allowed.
Where is that? No. Order number 121 also asks you to take appropriate steps for substitution after setting aside abatement. Where is the order allowing?
Lord, your lordship kindly come to the impugned order. Here it has been recorded.
Show me by which order the abatement was set aside.
Lord, order number 13(3). This order impugned order.
Yes, which place records that the abatement has been set aside?
Lord, kindly read. By petition dated 26th November 2024, plaintiff have submitted that as per direction of the Honorable High Court, giving an opportunity to the plaintiff to take appropriate steps for substitution of the legal heirs of added defendant number 10, Alimony Devi, by the order dated 13/3/24 in CO number such and such, and also as per order dated 9/5/2024 passed by the learned additional 12th Court, Alipur, plaintiff had taken steps for substituting the petitioner for condonation of delay.
And order dated 9th of September 2024.
And 26th September 24 allowed. This was allowed.
9th of September 2024.
That order is not there. That's not happened. It was allowed.
It was allowed.
Yes.
All right.
Allowed.
So now
by this court by order such and such, and a phase by plaintiff has been filed on 6/11/2024. The degree in this suit was drawn on 17/11/2017 against dead person, Alimony Devi, who died on 5th November 2005 at her native place.
No. Mr. Ghosh, I think show me your application under 152. In the 152, I think that is the earlier, the substitution of the other heirs.
Yes.
Where is your application under 152?
Page.
Yes, I have got.
Yes.
That is not paginated.
Yes.
No. Mr. Ghosh, you have not paid for setting aside. You have directly paid for amendment of the decree by substituting the name of the deceased heirs, of the heirs of the deceased. That is not the procedure.
Form is different form, but substance is similar. Otherwise, again, nothing is there to be
Correction of
put on
degree.
merit.
Mr. Ghosh, if it was substitution, I could have appreciated. There are Supreme Court judgment which says you need not pay for in so many words for setting aside abatement if the amendments are there. But no, here it's only amendment of the decree, nothing. You have not explained the delay also. Setting aside abatement, you have to state these facts.
No, in the application it has been stated.
Where is that?
That
152, this is the only application. You have not filed any application for setting aside.
152 application only simply for correction or the degree by incorporating the names of the
That cannot be done.
Because it is their fault. They didn't intimate that
Mr.
the
Ghosh,
defendant number 10 died.
Does the abatement stop
that I know.
with their, though they are under the order 22 rule 10 capital A, they are duty bound to inform.
Yes.
But the abatement will not stop. It's automatic. Starts upon after 90 days from the date of death.
But nothing should be hard on merit. Nothing remains to be hard on merit.
Nobody knows, Mr. Ghosh, that is the object. Why the decree is nullity? Otherwise, that principle would not operate. It's because a decree has been passed against a dead person. He did not get an opportunity to contest. That is the whole object. Why the decree is said to be nullity. Next steps. Yes. This matter.
14, 5 and 6. Mr. Mahathir.
Please let me run through the motions, thereafter I will come back. Yes. After item number 26. Yes. Yes, Mr. Rai.
Husband is the petitioner before your lordship. Husband is the petitioner before your lordship. Can you turn to page 15?
Husband is the petitioner.
Yes. Can you turn to page 15?
Today is fixed for argument.
As last chance.
Yes.
At that point of time, why file an application under section 36?
That has to be disposed of, Mr. Rai.
I am not on that. 2019 application filed.
2019
application filed that was dismissed, allowed to process to continue. At this point of time, file an application for maintenance. Section 36.
No, you said it was filed in 2019.
Initially, one application filed 2019 that was not pressed, or technically it was defective, rejected. After that, 2024, this application was filed.
Yes. Maybe it has to be disposed of one way or the other.
Yes, now another.
Rejected,
Now
allowed.
kindly consider the disposal. Now kindly consider how it has been disposed of.
Which that
Impugn order.
Yes. What is the order date?
I turn to the order number 49 dated 17/3/2025, fourth page.
Fourth page. Yes.
OP has filed documents to show that the petitioner minor here is the wife.
Yes, in the miss case.
Sometimes it
Yes,
continues.
Yes.
Actual concession price is rupees 22 lakhs and odd. Purchase of one flat at rupees 12 lakhs. If you affirm 46 years old, bachelor's degree in English honors. Scheme over the same, her aged mother, this is the liability of the wife. Now, the petitioner has annexed documents to establish that the OP is the director of Enforced Solution for company.
What is the date of filing of the application, Mr. Rai? 24.
24. No, my lord, the amount.
What is the amount?
This is the amount is rupees 70,000.
70,000 per month.
Income, it was
Your income is 70,000.
and
Yes.
rejected to pay rupees 25,000.
After all, you are paying to your wife.
I am not so much generous. I have to incur 24 lakhs for my father's cancer operation. I have annexed all those documents. If the wife is got 22 lakhs, wife got 22
Mr. Rai,
lakhs.
everything has to be, then your suit has also to be stayed.
Yeah, I'm ready. I'm ready. Then what is that adjustment? 22 lakhs? 125, we paid rupees 4,000.
Yes.
I am paying rupees 4,000. And she get 24 lakhs. Where is that adjustment? Where is that findings?
24 lakhs.
Yes.
24 lakhs she got from where?
By at the top, my lord, page 4. At the
2 lakhs 50,000.
2 lakhs 50,000 and purchase her own flat of rupees 12 lakhs. I forget 12 lakhs.
She has to reside somewhere.
Yes.
You are not providing the residence. You are not providing the residence.
My lord, if your lordship goes everything, then my lord, this doesn't come. What is the
What are you
finding?
doing, Mr. Rai?
4 companies, these are the companies that are recorded in the company's book. I am a paid director. I am not a shareholder director. That is a difference.
That is
My lord,
burglary of Companies Act. Not a shareholder director, not a...
I have produced all the income tax. It appears that
What is the finding of your income?
70,000.
And 125 has not been adjusted.
Not adjusted. Where is the adjustment regarding 22 lakhs? I am on that. 36, the language used in section 36 is different from section 24. My lord knows better than me. Language used in section 36 of this special is different from section 24. My lord knows better than me regarding.
So you want yourself to be maintained by your wife. That is
No,
the
that is
distinction.
24. This is
So
36.
that is the distinction.
No, apart from that, my lord, support. That you will maintain and support. That is what my lord 36 comprises support. 24 is maintenance. I'm not on that also. Yes, support includes that.
There are some decisions which says it's supporting.
What is that findings? My lord, I put this question, my lord, 24 lakhs, it will fetch them 30,000 per month. What is that findings to that effect? So I have to pay 30,000, my income is 70,000. As per this order.
30,000 is taking into that is 5,000 or
4,000 and odd, and it is 25,000, 30,000. My income is 70,000.
You have other income, Mr. Rai.
I don't know. That is why I
your suit has to be stayed.
That
if
is-
you can pay, I can expedite the suit.
I will consider the area. That much I have done. I must be candid with your lordship. Why? Otherwise, I advise my client to pay the amount and sought for expeditious disposal.
Let it appear, Mr. Rai.
As your lordship.
Yes. June month. Yes, next.
I am for the petition, my lord.
15, yes.
Is an application for expeditious disposal of the my lord suit.
Expeditious disposal of what?
My lord of my lord case number Act 8 from 1890. Lord case number 40 of 2023. Pending, my lord, since 23. Already 9 days has already passed. Lord, no steps by the my lord.
It's a hearing of the petition for visitation that is to be disposed of first. This
Let
application.
Petitioner, my lord, this is for expeditious disposal of title suit. My lord, suit is of 2004, my lord. Suit for eviction, my lord, or recovery of khas possession, area of rent and mean profit, my lord. My lord, if my lord sees the last two orders, my lord will find, my lord, this is at evidence stage, and also, my lord, fixed for ex parte hearing against the matter has been fixed.
This application under Article 227 of the Constitution.
Anytime, my lord.
Ex parte, you are the only party you can expedite on your own.
My lord.
There is no one to delay that. Yes.
I am for the petitioner, my lord. Only to the limited extent, only the observation made by the learned judge in the order itself, that is absolutely wrong. Not the husband of his own accord filed an application for withdrawal of the match suit. Your lordship kindly sees page 10, the application is there.
Yes.
Now the learned judge surprisingly finds
yes.
in the petitioner files a petition for withdrawing this case on the ground of that the matter has been settled out of court. That is not the contention of the petitioner.
Is withdrawn with liberty, but you have not sought for also liberty.
No, I am for the respondent wife. I am for the respondent wife.
Oh, you are for the respondent wife.
Yes. Lord, so far the withdrawal is concerned, I have no objection, definitely.
No, sir. You have missed out the ordering part. It says since dismissed as withdrawn with liberty. So the court has given liberty, but no liberty was sought for in the. You are
not liberty. The settlement.
Kindly see the order, sir. Ordering portion. Matrimonial suit be the same stands dismissed as withdrawn with liberty.
Yes, yes.
What liberty?
They have also in the application, your lordship kindly sees the application first.
In the application, they have not sought for any liberty, but the court has granted them liberty.
Yes,
you are not aggrieved by that.
No. That is, I am only for the first portion, my lord. The settlement, that is not there, my lord. The settlement is not there, my lord. There are several cases pending before this court also. In criminal division and another civil division is pending. That will prejudice my interest, my lord.
The petitioner
For expeditious hearing, my lord,
Of what?
of ex parte hearing, it is fixed for ex parte.
Yes. What is the suit?
Suit is for declaration and permanent injunction pending before the learned civil judge junior division at Barashat. And the defendants did not appear. That is why it is fixed on ex parte. The last order was on 27 January 2025. And in the meantime, it is, and the next date is fixed on 7/7/25. In the meantime, we have also filed an application for preponing the date, but it was
That
not
cannot be
considered.
preponed from here. That cannot be preponed. I can only direct this application under Article 227 of the Constitution of India is
Granting your lordship, Mr. Shonak Bhattacharya is appearing on behalf.
since I'm not inclined to take up this matter on personal ground, this matter stands released from the
petitioner.
Yes.
The petitioner is a plaintiff, my lord, in a money suit. Now, my lord, the defendant, my lord, produced two documents to be marked as, my lord, exhibits. Lordship kindly takes up the impugned order once, my lord.
Yes.
My lord, these documents are about two agreements, my lord, they tried to mark as exhibits. My lord, on 6th of January 2024, the learned trial court directed them, my lord, to produce the original. On repeated occasions, my lord, this order was made. They could not produce the original. So therefore, my lord, without any explanation, my lord, on 17th of January 2025, my lord, those two documents were accepted as exhibits. And my lord, my lord, in the pen, my lord, is written as secondary evidence. My lord, no explanation, my lord. Well, section 65, my lord, of the new act, my lord, nothing, my lord, 60, my lord, of the new act, my lord, nothing, my lord, complied with.
Yes.
My lord.
Why did not produce the original document?
Their documents, not mine.
You don't have the original documents with you?
No, their documents. Well,
was any notice served upon you to produce the document?
No, nothing. No, my lord, never.
Where have you stated that? Show me.
Well, in the revision.
Basic foundation for leading secondary evidence was not there. Show me.
Well, from secondary evidence, not mine. Their secondary evidence.
Yes. Basic foundation has to be there. Where have you stated that there is no basic foundation for leading secondary evidence? Where from it would appear? Sir, where is the copy of the evidence?
But supplementary evidence, the evidence would be brought on record. The evidence.
This type of orders, if you want to challenge evidence,
I'll bring on record.
You have not produced the evidence. It's not with you. How could you draft this petition? Without
my
having
lord,
a
only
copy
my
of
lord,
the
kindly
evidence.
considers the order impugned itself, my lord. The basic, my lord, the statutory provisions, my lord, for my lord, the acceptance of secondary evidence, my
Statutory
lord.
provisions can be decided from here. What are the basic foundations from here?
No, my lord.
Other things are to be looked into.
Well, but my lord, for secondary evidence to be adduced, my lord, there has to be a basic, my lord, plea from their side that the original cannot be produced as, then there has to be application, my lord, that has to be adjudicated. After that only, my lord, the documents can be, my lord, adduced as secondary evidence and accepted.
So produce the copy of the evidence.
My lord, evidence I'll produce. I'll produce.
After some argument, the learned advocate appearing for the petition. Yes, Mr. Haldar.
In a suit for eviction on the ground of default and reasonable requirement, 7-2 was filed, my lord, sometimes in 2012. For last 13 years, it is pending for
7-2 pending?
Yes, my lord. It was filed on December 19, 2012. And no date is being fixed for that. Thereafter, my lord, the date was fixed for hearing the 7-2. Thereafter, my lord, the defendant did not turn up. Suit was posted in the ex-parte board. Ex-parte order was vacated. Subsequently, my lord, no date is being fixed for hearing the said 7-2 application. It was filed on December 19.
Haldar, you could have drawn the attention of the learned trial judge. That, it has not been fixed. Show me that you have drawn the attention of the learned trial judge.
It was not. It is not being called on for several dates. That is the reason why, my lord, I have
not bring that fact to the notice of the learned trial judge.
Anyhow, my lord, there are
filing an application.
Two applications are pending, order 39 to 1 and 2.
It
And
is a different thing altogether. Your allegation is that 7-2, no dates have been fixed. So what have you done to bring the note to the notice of the court that this was not, date was not
matter is not being called on. That is a difficulty.
Mr. Haldar, what prevented you from filing an application for fixing a date?
Anyhow, my lord, that is being.
That procedure is not being followed in the trial court. That cannot be done.
That can
I'm
be
asking you whether that can be done or it cannot be done.
Can be done.
So,
anyhow, my lord, I am seeking a direction of the
a civil lawyer could have advised your client for that. What was the last date? From 2013, thereafter, no dates have been fixed and you are keeping quiet. It shows that you are not very diligent in proceeding with your suit.
Change brief, my lord. That is the
You have to also accept the liability, not only the asset. service. You also communicate the order as well as this application. Yes, next.
22, my lord, another eviction suit, my lord.
Same thing.
No, my lord, same landlord, that tenant is different. My lord, in the instant case, my lord, 7 to disposed of, but my application for local inspection for ascertaining the accommodation available to the plaintiff, that was filed on January 28, 2020. This interlocutory application is pending for last 5 years.
Mr. Haldar, your client does not want eviction.
No, my lord,
This is also a suit of 2012.
my lord, the same landlord, same suit.
This shows he is interested in earning from his tenants.
Change, my lord, thereafter I was contacted, my lord.
Now you are trying to expedite.
What can be done?
This application under Article 227 of the Constitution of India is at the instance of the plaintiff. I can adjourn Mr. Kormokar. The next is not in my hand.
Next will be not before 8 May.
Well, they did not file their objection. They come up
Mr.
challenging.
Kormokar, I can expedite the hearing before the Learned Appellate Tribunal. Fixed on 8th of May. You are only challenging an interim order.
Interim order.
So the main appeal is pending. It has been fixed on 8th of May. I'm directing the Appellate Tribunal to dispose of that.
But the issue before your lordship today is not whether they are entitled to that interim order or not. That's it.
When this order was passed?
The order
13th of March 2025. So now you have suffered this for more than 6 weeks.
Lordship
So
was
can you not?
We had the first available opportunity, my lord. I am before your lordship.
I'm not against that. 8th of May, I'm requesting the Appellate Tribunal to dispose of the appeal. I think that will be the end of the matter. Everything will go by that.
8th May.
8th of May, that is I've seen only the order. List
let-
8th of May for hearing, provided you have filed your opposition and other things. I do not know whether you have filed your opposition.
Opposition file করেছি? Lord, we'll file the opposition within that time, Lord, kindly.
After some argument, Mr. Kormakal, learned advocate, appearing for the petitioner, 24.
My lord, in 24, I am appearing for the petitioner. There is a prayer for expeditious relief of one title appeal, which is pending from 2022. The respondent and the petitioner herein appeared in the title appeal, and
So
thereafter.
title appeal has been fixed for hearing on 14th of May.
Yes, my
This application under Article 227 of the Constitution of India is at the instance of the petitioner praying for a direction upon
They want to repair this kind of premises, repairing application.
Yes.
Now, my lord, what happened, my lord, the last
Has
date.
to be decided. It
That has to be decided. I'm
So
not.
I'm directing the learned trial judge to decide the application for repairing. It's ready. Objection you have filed.
My lord, yes, my lord, my instruction goes, my lord, it will be filed, my lord, because last date was
Will be filed.
my lord, it's fixed on kindly says after 4 months. 8th of, it was filed in March, fixed on 8th of July. So, my lord, after,
I'm also fixing matters after 3 or 4 months. Mr. Chair.
my lord, kindly appreciates, my lord, the authorities have issued
That is the
notice
pressure
upon
of
me.
the war. Can't be helped.
My lord, authorities have issued notice upon me. My lord, the building is in such a condition, it will
You
fall down.
repair it.
My lord, it's not repairable. It's not repairable.
So you want to evict by demolishing?
No, my lord, that's why I filed a suit. This is the suit for removing the illegal encroachers. My lord, they are not tenants.
Let it be ascertained whether it can be it is repairable or not. Let an
My lord,
engineer
you
be
kindly sees the notice. That's why, my lord, this notice was also brought to the notice of the trial court.
from the corporation.
Municipality.
Yes, yes. You invited that notice,
No,
Mr.
no.
Chatterjee.
My lord, that's why photographs is annexed.
Yes, yes. Photographs. You are instrumental in getting this issuance of notice.
No.
All these things are.
That's why photo kindly says if this is repairable in any manner, my lord, I would have repaired. My lord, this kindly look through the photograph, my lord, page 23.
Whose opinion you have taken that it's not repairable? It's your own opinion.
My lord, you kindly sees the notice, the way the notice has been.
Let us forget about the notice.
Well, they are
What opinion you have sought for?
My lord,
For
from a,
coming to the conclusion that it's not repairable.
my lord, from bare naked eye, I am submitting. Like naked eye, photographs, my lord,
You are an
speaks for
expert.
something.
Mr. Chatterjee, now you have also become an expert.
No, not an expert.
Ashun, Ashun. This
My lord,
application under Article
my lord,
27 of the Constitution of
the
India.
issues may also be framed.
Yes.
This is my application for transfer of the matrimonial suit pending before the additional district judge fast track court to Barakpur to the London district judge at Kalyani Nodia. My lord, I am appealing on behalf of the wife. My lord, the two proceeding has been pending in the Kalyani court. My lord, the DB Act proceeding as well as the matrimonial proceeding.
This application under section 24 of the Code of Civil Procedure is at the instance of the wife paying for transfer of the matrimonial suit presently pending before the learned additional district judge fast track court
Because my lord, because my lord, in the court in the website in this
তাহলে ওই লিখে দেবেন আগের নাম্বারটা
4,
Pass over next.
I 4 minutes. I am for the petitioner.
You are not there.
Yes, sir.
Where is your other side?
For the opposite party, my senior is outside.
Yes.
Pass over, yes.
5.
This for extension of interim order.
On the last occasion, my lord expressed the view that matter may be disposed of because my lord it is relating to execution.
Execution.
Yes.
47.
47 has been rejected.
To be hard, Mr. Extending and fixing.
My lord,
47. Many points are involved in section 47.
my lord, kindly then fix a particular date, my lord.
Yes, yes, I will fix a particular date. I will fix a particular date.
It will never be
Taken up. Contested applications will be
It
taken
will
up.
never be hard, man.
Mr. Mahato, please keep a watch on the list. It will be taken up.
Contested application will হবে.
Please.
Let it be contested application, but kindly fix a date, man.
I have fixed the date, 7th of May, the monthly list, or 5th of May. 5th of May, monthly list will be published.
Monthly list, my lord knows, my lord.
Yes, next. 4 and or 5 and 6.
Same.
5 and 6 same. Now title execution case number is different.
Correct.
So that দেখে নেবেন, title execution case number is different. Yes. Call the next matter.
11. I am playing for transfer of the proceeding, my lord, from Alipur district judge court to Purbo Bardhaman district judge court. I am for the petitioner wife, my lord. Husband filed his matrimonial suit, my lord. I am residing at my paternal home, my lord, at border of Bardhaman and Bankura district, my lord. From my place to Alipur judges court is 148 kilometers, my lord. I am residing with my minor daughter.
This application under section 24 of the Code of Civil
My lord, it's for appearance, my lord. It's at Alipur, my
Appear,
lord.
nothing
Kindly
will happen.
give me a short stay, my lord.
Nothing will happen.
Otherwise, my lord, I am
The client could come to Calcutta to affirm this affidavit. Please ask her to appear. Yes,
a
next.
short stay, my lord. I am residing with a minor daughter, my lord.
Okay,
He is studying at class 2, my lord.
Good man.
A short stay,
Yes,
my lord.
four. Yes.
But kindly a short stay, my lord. Otherwise,
Please
I have
appear. It will be taken up.
158 kilometers.
Yes,
my lord.
yes.
Board members, I am for the petitioner. The matter has been
Yes,
settled between the parties.
Settled.
But I don't know, my counterpart of the court below informed me, he approached to the, at the afternoon yesterday, showing his inability to pay anything, and he will vacate by next 7 days. It is fallen from him.
My lord,
His
it is
time.
exact opposite. It is exact opposite. I have been approached. I have been approached, my lord. I am saying it with confidence. I have been approached.
They man
Yes.
vacating this. If he is disputing, nothing can you say.
My lord,
It has been settled.
He is supposed to come up
They man vacating the interim order.
My lord,
Are you willing to file affidavit?
my lord,
With
I
regard
have been
to this?
my lord, I am saying I have been approached that I have to vacate by April 30, this April 30, and no occupational charge will be paid. I have agreed to that.
You have agreed to that?
Yes.
So file an affidavit to that extent.
My lord,
That will
has been
vacate.
settled between the parties. So they have said if he is
He is
saying,
disputing that. He is
But settlement, I
disputing.
don't know. It is from his side.
my lord, this advocate, their learned advocate in the executing court have said.
Yes.
Please take instructions from your conduct. He says that the learned advocate.
My lord,
Why I
he
will mislead the
suggested
court?
without paying anything as
Whether your counterpart has agreed to that.
yes, he agreed.
Then
he agreed. So, my lord, in that event, my lord, I pray only one thing, my lord. The pending appeal may be treated as dismissed as withdrawal from his end. Otherwise, my lord, it is on 28th.
All right, this stay is till the end of April.
Yes.
So he
And
will
second
vacate.
May is fixed for delivery of position further on.
I'm not passing it. I'm
Yes.
only adjourning this matter. The learned advocate appearing for the petitioner submits
And my lord,
that
that withdrawal of the
and thereafter he disputes. He agrees every
it
day.
seems your client is very smart.
It is the second time he stalled the
It
execution.
seems your client is very smart.
Anything and confusing the court and
All right.
Yes,
Yes.
they have agreed.
Please come on Monday.
you have to come with affidavit today.
Yes, I will come.
Yes.
By 4:30 I will
Yes, on the
come.
next matter.
7.
Yes.
Lordship, this is the MSCC case, Lordship.
Yes.
The petitioner filed a petition for evidence of the doctor, but the learned judge, additional district judge, Shalda rejected the said petition.
Which petition?
Yes. Kindly come annexure.
What is the order impugned? 19th of February.
Yes. Kindly come annexure.
Who are you?
I am petitioner.
You
Appear
are
on
the
behalf of the
claimant.
petitioner.
You are the claimant.
Yes. Kindly come annexure D, page 35. This is the petition, my lord.
What happened on 25th of March 2025?
25th March 25.
Yes.
Yes, my lord. Lordship, kindly come.
What happened on 25th of March 2025?
Lordship, kindly come 19 February 2020.
Yes, yes, I am at 19th February. The next date
Adjournment.
was fixed on 25th of March. What happened
Yes,
on
there
25th
was,
of...
the petitioner has taken adjournment with there.
It was adjourned. What is
Yes.
the next date fixed?
Yes.
What is the next date fixed?
Lord, next date, I did not know, my lord. The learned judge, my lord, the learned judge rejected the said petition for wrong finding, my lord. Wrong finding. Lordship, kindly
What is
come.
the wrong finding?
That the learned advocate of the claimant made a prayer for reopening the witness, my lord.
So this is the wrong recording of the order.
This is the not wrong recording. Thereafter,
Yes.
it appears from the case record that the said claimant, by proving a letter submitted before the tribunal 21 February 2024, that all the documents were lost. My lord, the original documents were lost. Then they file a complaint
Where
to
is
the...
that letter which you produced on 21st of February 2024?
My lord, every
Where
document...
is that letter?
What?
Sir, show me the letter which you filed on 21st of February
This is
2024. Where is that letter?
I am showing, my lord. My lord, GD 19 to 2021, my lord. This is the my lord. Lordship. GD. File a complaint letter, then the police station.
Where is your application under dated 14th of November 2014?
Yes, yes. Annexure D, page 35. my lord. Annexure D, page 35. My lord, all documents such as medical were lost.
Where have you stated that in this application? It has not been stated.
Yes, stated, my lord, this is the petition
Yes.
for the police station.
That may be so.
Yes.
Show me from your application dated 14th of November 2024. You have stated that it has been lost. You have not stated that fact.
Before that, affidavit in chief I have filed, my lord. Then original documents have been lost.
That is a different thing altogether. This application was only considered.
Yes.
Here you have not stated that the documents were lost. Show me where have you stated.
In this petition,
Then
It has not straightened.
yes. This application under matter.
Time for the petitioner. If the husband is the petitioner before your lordship, in an Act 8 proceeding, both custody as well as the visitation right was asked for.
Yes.
Your lordship has a there is a previous order directing the learned trial judge to dispose of the matter within 1 year. That coordinate bench direction have annexed. If your lordship takes up page 33 of my lord's brief.
Page 33.
1 year from the interlocutory application within 2 months, and thereafter to dispose of the main Act 8 proceeding.
Yes.
Your lordship had an occasion to deal with this matter in one of the revision at page 58 of my lord's brief. Kindly remembers that there was a application filed by the husband for assessment by child welfare committee regarding the mental condition of the child, because he is behaving like a irregular manner to his father. Then they have took out an application before the trial court. That application was allowed by, on the instance of the husband, they took out an application for recalling, stating that no welfare member should be appointed on the behest of the husband.
Application for modification.
That it can be by a neutral person appointed by the court. Noticing that, and they have challenged that order also, allowing my application. Your lordship noticed that since you have filed a modification application, let that modification application be heard out.
What happened thereafter?
Thereafter, after your lordship's order, they filed a fresh application, taking a complete different view. Page 61 of my lord's brief, that application,
yes,
stating that they doesn't want that order should be recalled as a whole. Nevertheless, my lord, that is not tenable in the eye of law. But my lord, kindly see the last impugned order, not impugned, my lord, the last order. The learned judge now, my lord, has kept this. My lord, by virtue of all these things, my lord, I am not able
What
to
is the
see
date
my
of the
child.
order?
My lord, the 24th March 2025 is the last order. My lord, I am asking only, my lord, this frivolous application to be heard out.
24th of March.
My lord,
Yes.
last order.
Yes.
This is a fresh 151 that they have filed, asking for recalling of that order as a whole, completely, my lord, taking a different stand. My lord, kindly direct, my lord, the learned judge, my lord, to hear out this expeditiously. I am not able to see my child.
25th of April 2025, what happened on that date?
No, my lord, 25th April is, my lord, tomorrow.
Yes.
Kindly, my lord, directs that.
এটা আগে করে দেবেন, কালকে দিন আছে তো, এটা আগে করে দেবেন, কালকে দিন আছে। Yes, next.
This matter,
Yes.
petition.
This is
District Judge Alipur, my lord, has rejected my application, misapplication in connection with the appeal, wherein I am the appellant. Order 23 Rule 9. Along with this, my lord, I made an application, Section 5, read with my lord, Order 6, Rule 17. Actually, my lord, my learned advocate, my lord, did not appear. That is why, my lord, my learned advocate for some time, my lord, did not appear. That is why, my lord, actually, my client is a rural people. Totally, my lord, illiterate people. He depend
no,
upon
your application under Order 22 Rule 9 was rejected.
along with my lord the Section 5 and made an application for amendment of that application that has been rejected. Well, I am very candid, my lord, due to my lord latches on the part of the my lord. You see, kindly see on several days, Landed Court give the opportunity. But Landed Court, the
Order 6 Rule 17, what do you want to amend?
Actually, initially, my lord, initially I
At
made
the appellate stage?
no, your lord, see, kindly see, my lord. Initially, Order 22 Rule 4 application was there. But
no, Order
out
6
of
Rule
time,
17 to amend Order 22 Rule 9.
no, thereafter, my lord, it was shifted to my lord Order 22 Rule 9 because there was amendment was there.
Yes.
Along with
No,
this, I
Order
made an
6 Rule
application.
17 for amendment of what?
Amendment of my lord the Order 22 Rule 4 because
Order 22
substitution, that was substitution.
So that was rejected.
That is rejected as the advocate did not appear. That is why. This is the whole case.
Advocate did not appear.
My lord,
So it is to be
2 or
dismissed for
3 days,
default.
my lord. That is the whole case.
By the order impugned, the application
I beg to appear for the petitioner. The
interim order August. Yes.
the plaintiff is the petitioner before your lordship. By dint of the order impugned, my application in essence, Order 13 Rule 3 for marking a document of as an exhibit has been turned down on the ground that it has not been backed by pleadings in the plaint. But it has been backed. That's a perverse finding. My lord,
What is that?
My lord kindly takes my.
What is the document?
Document, my lord, is a suit for defamation. In the suit for defamation, my lord, the PW4 comes and says that he's a co-trustee with me, and we had opened a dispensary, a charitable dispensary. That document, my lord, has not been exhibited.
No, where is the finding?
Finding, my lord, would kindly takes the order impugned. The
10th of March.
Yes, my lord. 10th of March, order number 25.
Yes.
Second page, my lord will find moreover the crux, third paragraph.
Yes.
Crux in the case is whether lodging of the miscase by the defendant against the defendant allegation of false, and whether because of that false allegation, the image of the plaintiff has been lowered in the estimation of others or not. The issue is not how much social status the plaintiff has in the society. Thereafter, my lord, I am to prove my social stature. Now kindly takes the second last paragraph, my lord. Thus, in view of the above discussion, the plaintiff has made the attending facts and circumstances, it is clear that the trust deed which the plaintiff proposed to exhibit is beyond pleadings.
Yes, where is the pleading?
Now, pleading, my lord, would kindly takes my plaint. That, my lord, starts at page 8, first paragraph.
Yes.
My lord, the plaintiff do hail from a respecting family of the village such and such, having high professional reputation, carrying on business in export and import and wholesale business in various foreign countries as well as regional distribution in the locality. And he enjoys a great respect from the neighboring people as well as the people in the view of these.
So where is the trust deed? Trust deed is not being referred to.
No, trust deed has not been referred to.
That is the finding.
But that is the finding. But my lord, in order to prove my social stature there in my native place, my plaint case was that my native.
That can be proved. For that, trust deed is not necessary.
Trust deed, my lord, that
why trust deed is necessary?
The charitable dispensary is being run. My lord,
that is not your case either.
But kindly takes the examination in chief. That
is a different thing. Where is your case that you run a charitable dispensary?
I have said that I have been well regarded in the locality and I have been considered as a man of high repute.
Yes, for that, why trust deed? Trust deed is a different thing altogether. How the trust was formed. How do you prove that? Whether Mr. Banerjee.
Yes, madam. Yes, sir. The trust deed, madam, it would show that that dispensary is in existence, and I am running that dispensary.
That no trust deed is with regard to the formation of creation of that trust. How that is relevant?
Once takes the examination in chief. Once.
Yes.
Well, kindly takes. Kindly takes page 24.
Yes.
For paragraph 11, this is why it is becoming essential. The plaintiff primarily and his brothers approached me to build a charitable.
Yes, assuming this, so you have created a trust. How that is relevant for the purpose of proving the damage done to your reputation?
Then only one thing, my lord. The learned court has, in his order, my lord, directed fixing for payment of cost and further for PW1. Then, my lord, this particular witness.
Yes,
should get a chance to depose without the trust deed. My lord would kindly indicate in this.
That has been closed. Where is that?
It has not been closed. It has not been closed.
So in default.
In default.
So 21st of April, what happened on 21st of April?
My lord, I have been given 1 month time to produce an order of stay before the.
So it's been it has not been closed yet.
Not yet closed. My lord would kindly record that. My lord, I will be giving evidence. My lord, this particular PW4 will come and
this application. None appears for the petitioner at the.
My lord, I am appearing on behalf of the petitioner, my lord.
Yes.
My lord, petitioner has purchased plot of land from one patta holder, and my lord, when he is in possession 1.5 year, my lord, suddenly he found that one title suit has filed against them, my lord. My lord, if your lordship kindly come page 39 of my petition, my lord. My lord, at bottom on field inquiry, it appears that
is the order you are challenging.
my lord,
What are you are challenging?
one ad interim order has passed against me, but I am still possession for 1.5 year, my lord. If your lordship kindly come page 39, my lord, I am in possessing. I am also possessing over the land.
Which you are challenging? Which order you are challenging?
Order number 2, my lord. Ad interim order, my lord.
Ad interim order of injunction.
Injunction, my lord.
So an appeal lies.
My lord. Actually, it is borrow season, and my crop has grown up, my lord.
That is a different thing. An appeal lies.
My lord, kindly give me liberty, my lord. File appeal, my lord.
Yes. By the order impugned. What is 7th of February order?
My lord, it is for extension of the interim order, my lord.
By the petitioner has challenged the order number 2 dated 9th of January 2025, by virtue of which the learned trial judge passed an ad interim order of injunction on an application filed under Order 39, Rule 1 and 2 of the Code of Civil Procedure. First up, the ad interim order of injunction passed on 9th of January 2025 was extended by the order dated 7th of February 2025. First up, the petitioners have challenged both the orders in this civil revision application. First up, the orders impugned are applicable under the provisions of Order 43, Rule 1, within bracket small r of the Code of Civil Procedure. In view thereof, this court is not inclined to entertain this application under Article 227 of the Constitution of India. First of all, at this stage, the learned advocate for the petitioner prays for leave to withdraw this civil revision application with liberty to approach the appropriate forum in accordance with law. First up, in the light of the submissions made by the learned advocate for the petitioner, CO 1347 of 2025 stands dismissed as withdrawn with liberty to the petitioner to approach the appropriate forum in accordance with law. The learned advocate on record of the petitioner is permitted to take back the certified copy of the order impugned upon replacing the same with a photostat copy thereof. Yes, call the next matter.
Item 32, Lordship, I appear on behalf of the petitioner. Lordship, petitioner prays for expeditious disposal of an application of a miscase under Order 9, Rule 13, filed by the judgment debtor opposite party, Lordship. There was a previous direction in June 2021, Lordship, that is at page 21, Lordship, where it was directed that the miscellaneous case shall be disposed of.
Under Article 227 of the Constitution of India is that
Opposing this application, my lord, before my learned friend starts, my lord, may I have a copy of the
My lord, yes, my lord, I am for the opposite party, my lord. No copy has been served, my lord.
There is no
This is a-
caveat, my lord. I am not
No, no,
supposed
I
to.
understand, my lord. I understand.
Lodged
My
a
lord,
caveat.
my lord, may I? My lord, there is
I have no
similar
difficulty serving
application.
it.
My
Anyway.
lord, may I? Just 1 minute, my lord. No, my lord, they have already, my lord, filed applications under 227 from an order passed in this proceeding. It is pending before your lordship as item number
133, 134.
133, 134. I was on caveat in that.
May I? Lord, I have an urgency. I'm here and now serving a copy on them. Kindly keep it tomorrow. Kindly keep it. I'm here and now serving a copy. Urgency. Well, I mentioned this
When
matter.
this matter is taken up for hearing, Mr. Rao, Learned Senior Advocate, appears for the opposite party and prays for a direction upon the petitioner to serve a copy of this application upon the Learned Advocate on record of the opposite party. First up, the petitioner is directed to serve a copy of this application.
I'm serving.
The petitioner, it is hereby recorded that the petitioner has that the Learned Advocate on record of the petitioner has already served a copy of this division application upon the Learned Advocate for the opposite party in court today.
Kindly keep it
List
tomorrow.
this matter tomorrow under the heading motion. Yes,
Very
next.
grateful, very grateful.
My lord, there are two other, my lord, civil relations, my lord, which
Yes.
is filed, which is appearing
My lord,
as item numbers 130.
They are appearing. Those
Those
matters are appearing. Yes, call the next matter.
my lord, only one prayer, my lord. Let it retain its position, my lord.
Yes, yes. Yes, next.
Yes. ठीक है.
Yes.
Lord, one permission has been granted by the order impugned to hold the permission has been granted to the defendants, opposite parties, to hold the Kali Puja on a particular sued land from 20th of April.
Kali Puja is long over.
No. This is special Shashan Kali, etc.
When?
From 20th of April up to 3rd of May. And
it has already started, Mr.
Already
Rai.
started. What I suggest before your lordship, my lord, let me serve.
What will happen, Mr. Rai?
Only kindly observe that this order will not create a precedent for the next year. That can be done, lordship. I know there will be pandemonium.
Hi.
My lord, item number 35, my lord, I am appearing for the petitioner, my lord. In this matter, my lord, Mr. Mohit Mukherjee is appearing, my lord. My lord, I am praying for the day's accommodation, my lord. He is not
On the
bail.
prayer, Mr. Bhattacharyya, you are appearing. On the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned.
6.
None appears for the petitioner at the time of call. No accommodation.
Without opening the papers, my lord.
So bad a case.
It concerns the plight of a 6-year-old child. I am the mother. In a custody battle, my lord, an order was made by the court below previously declining, my lord, physical visitation. My lord, in an 151 application, my lord, by twisting the language and by presenting it in such a way, my lord, the father has been able to persuade the learned court below to grant him physical visitation rights, my lord, as well as virtual. And my lord, till date, I'm the mother. My lord, kindly,
do not have any right to
kindly one sentence more. One sentence more, I stop. From the date, my lord, of the separation, my lord, separation in the sense, my lord, they are living separately. You know, the father stays in Punjab, Ludhiana, or somewhere. You know, the wife stays in Calcutta. Not even a rupee has been sent. That is a different proceeding, maybe. But, my lord, kindly visualize. There are series of cases against inter-se parties. And what I am strictly on is, my lord, apart from anything else, my lord, Mr. Basu wants me to tell this to your lordship. If it comments to your lordship, if your lordship appoints anyone, a third party, in whose presence this visitation takes place, we don't have any problems. 1. 2 is, my lord, they have to pay because, my lord, the mental faculty of the child is being affected.
So the child is in Kolkata.
He's in Kolkata. He's studying. She's studying somewhere here.
The child is in Kolkata. How the visitation? So the father comes from Punjab.
My lord, apparently the direction is yes, he has to come.
Yes. So there is no difficulty.
No, my lord,
why are you opposing
the child is not very keen in meeting the father. We have videos. My lord, the virtual visitations, my lord, which
might be for some reason.
No, my lord,
you know instrumental in
because I am not instrumental.
I'm not meaning you, your client.
My lord, of course not me. Why should I be instrumental? My lord, kindly once.
You saw
child was
the Bhattacharyya, no interim order can be.
The child was privy to whatever.
No interim order you serve.
My lord, the matter is coming up before the learned court below on the 28th. Kindly, my lord, restrains the court below from proceeding. My lord, we'll come back to your lordship on the 28th.
Why?
So,
proceeding, let the proceedings continue.
My lord, what I am on is, my lord, this physical visitation should not be insisted. So, kindly seize the orders.
Bhattacharyya, please serve. Please serve. Let the proceedings. Why are you stalling the proceedings?
No, in the meantime, my lord, no insistence on physical.
Mr. Bhattacharyya, impugned order. This order cannot be stayed.
That insistence on physical visitation should not be insisted.
Let
my lord, kindly seize the 2 orders.
Mr. Bhattacharyya, you serve.
Well, I will.
Nothing will happen. Nothing will happen.
Visitation, my lord, should be, my lord, at least till such time your lordship hears it any day convenient to the court. My lord, will.
Where is the, how soon can you serve the father?
My lord, the father stays in, my lord, Ludhiana. My lord, we'll serve it by speed post with acknowledgement due in course of today.
Yes. Any email address available?
Baba? We will try to find. We'll send it by email. We'll come back tomorrow. Monday, Tuesday.
The petitioner is directed to serve a copy of this application upon the opposite party by registered speed post with acknowledgement due, as well as through email, electronic mail, and file an affidavit of service on the next date. Establish this matter. Next week, Thirtieth.
Only the matter is coming up before the learned court below on the 28th.
Nothing will happen. Yes, call the next matter.
Very
Call the next matter.
30th তো থাকবে সার্ভ করে দিস ইমেলেও করে দিস
38
Wait, I'm the petitioner, my lord. Against the order, my lord, first under order 7 rule 11, my lord. What that point for, my lord?
Order?
Order 7 rule 11 application was rejected, my lord. Against the order, my lord, I can be ruled. My lord, page number 14, my lord. Initially, my lord, once Supriya Rai filed a petition suit against this petitioner, my lord. Subsequently,
what is the ground under order 7 rule 11?
There is no cause of action mentioned in the plaint, my lord. Lord, you can plaint for the moment, my lord.
Failure to disclose a cause of action.
Yes.
What is the failure to disclose a cause of action?
My page number, my plaint. Page 42.
Please fight the suit. The failure to disclose a cause of action according to you, but some cause of action has been.
No,
where is,
lord,
where is the
page
plaint? Where is the
42,
plaint?
Page 42, my lord.
Page. Where is the plaint?
Page 42. The third plaint.
Third plaint.
Well, for a moment, my lord. First plaint was filed by Supriya Rai. Page 14. Page 14, my lord. First plaint, Supriya Rai. Thereafter, another suit filed by Bodum Chandra Rai. Thereafter, by Landlord personal order, the compensation suit may be plaint may be filed. Accordingly, this compensation plaint was filed against 7%. Initial suit was against 4%, my lord. I am not the co-owner of the property, my lord. The petitioner is not the co-owner, my lord.
Whether he is the co-owner or not, that cannot be decided at the stage of. That cannot be, sir. That cannot be decided at the stage of order 7 rule 11.
That is demarcated portion, my lord.
Yes, that is the matter of evidence. Whether it's demarcated, not demarcated, how demarcated, between whom, demarcation. Those are matters of evidence.
The person who sold this property, they filed this suit against me, my lord.
Sir, those are. Please produce the evidence. You will succeed in the suit.
Page 42, my lord.
Why are you shying away from filing your? Have you filed your written statement?
Yes, my lord, everything.
So I'm directing the. I'm expediting the hearing of the suit.
For a moment, my lord. Page number 42, my lord. Page 42. The plaint, my lord.
Yes.
But there is no mention of cause of action. When the cause of action is against me, my lord.
Why they, according to you, they have no cause of action?
Yes, my lord.
Because they have purchased demarcated portion.
I have purchased, not I am purchased, I am the purchaser.
Yes, you have purchased a demarcated portion, so you are not the co-sharer.
No cause.
So a partition suit is not maintainable.
No, my lord. But this plaint does not disclose any cause of action. Inter plaint of the reading, my lord.
What is the suit for?
Suit for partition.
Suit for partition, according to you, you have been included in a suit for partition, and you are not a co-sharer because you have purchased a demarcated portion. That is the. This is all.
My lord,
I am for the private respondent, your lordship. Can your lordship direction to sub-copy, your lordship?
Even after hearing these observations, you want all right of when this matter is taken up for hearing the learned advocate for the opposition.
I am for the
39,
petitioner.
yes.
My lord, I am for the opposite party.
My lord, by an order dated 18th of March 2025, the learned court below has asked me to file a statement with all the accounts regarding the amount paid till date. I am the husband, my lord, over here, and have overlooked that I have and overlooked the point that that maintenance cannot be compounded, my lord. If my lord comes to the second part of
the order impugned?
The last
For filing the statements, the court has not
No, my lord,
compounded
no.
or anything. The court has said 35,000. I have directed you. You have paid. You are saying you have paid 35,000. Kindly show the statements. Kindly put in an account.
File the statement
What
of
is the-
account.
my lord, can you come to the second last page? Second last page, my lord. Second last page.
Yes. You file the statement of account.
My lord,
By the.
my lord, they have asked for 70,000. They are saying 35,000 over here and 35,000 over
Please produce the statement of accounts that there is no arrear by this application.
My lord, item number 40, I beg to appear on behalf of the petitioner lordship.
Yes.
In a suit for eviction, I am the defendant, my lord. The plaintiff did not appear. The learned trial court dismissed the suit for default on the ground of default. Thereafter, lordship, the plaintiff filed an application under 151 stating a prayer that they wish the suit to be restored to its original file and number under 151, lordship. No copy was served upon me. I did not have any notice. It was allowed, my lord. Kindly seize the impugned order, lordship. My lord, normally, if I'm not wrong, my lord, subject to correction by my lord, Order 9, Rule 9 has to be filed as a separate miss case. Moreover, lordship, as per subsection 2, no order shall be made under this rule unless notice of application has been served on the opposite party. And my lord, the third limb of my submission is that it was beyond the period of limitation. There was a 30 days period of limitation, my lord.
The petitioner raises an arguable point as to whether an application under section 151 of the Code of Civil Procedure is maintainable for restoration of a suit which was dismissed for default when there is a specific provision under the Code of Civil Procedure for restoration of the same. So the petitioner is directed to serve a copy of this application upon the opposite parties by registered speed post with acknowledgement due and file an affidavit of service on the next date. List this matter under the heading contested application in the monthly list of July 2025. First of, there shall be an order of stay of all further proceedings in title suit number 357 of 2021 till the end of the month of August 2025 or until further orders, whichever is earlier. Yes, call the next matter.
Deeply obliged, my lord.
One, my lord, I
will not be reached.
No, I say, kindly come to you.
If a matter is not within 5 matters,
every one of us is very anxious of getting the matter heard by my lords, but my lord may not.
According to your estimation, if it is not within first 5 matters, it will not be reached.
No, sorry.
Yes, Mr. Vadajaji.
My lord, kindly come to page 28.
Yes.
Page 28, the relevant portion is at page 30. My lord, the affidavit of service.
What happened? What is the order?
Yes, now, my lord.
That is the impugned order. This is the impugned order.
This is the no.
You have not filed a certified copy.
My lord, what? This is the impugned order, my lord. I just say, my lord, that after this order was passed, since the occupational charge, which was directed to be paid, there was no direction that to whom the occupational charge has to be paid. And my lord, there are about 125 tenants, my lord, in the particular premises. Now, my lord, I only want, give me a small time. Small time means, my lord, even 2 days, 3 days, 4 days, whatever my lord pleases, so that we can deposit.
What is the amount which you have to deposit?
But, my lord, your lordship may kindly.
So by this order dated 21st of March 2025, you are directed to pay occupation charges.
Yes.
And by what time?
This third page. Page
Yes.
30.
Yes. 26th of March.
26th of March.
You are directed to pay. No, first of such installment to be paid by 26th of March, second by 2nd of April, third by.
I have to deposit.
Yes, deposit. So you are the defaulter of 5 installments, Mr.
Miller, kindly, that's the reason I told you, Lordship Miller, that kindly give me 7 days.
Yesterday you gave an impression that it was only 1 or 2 days of one installment.
No. From the kindly.
What is the amount?
The total amount.
Installment, total amount.
Miller, that has been indicated, Miller, here.
No, I am asking you, what is the amount which you have to pay for 5 installments?
11 lakhs 20,000 on instructions.
5 installments.
Yes.
Yes. How soon we will pay, Mr. Vadajaji?
No, my lord. Subsequently, this order has been vacated.
Miller, I can deposit
this order. No, kindly see the last order.
Yes. Recalling.
No. They have to challenge this order. That earlier order.
I am Miller.
It was vacated, recalled because they did not pay. Now you are getting the money. If that amount
I
is
want
deposited.
to pay.
Yes, yes. How soon we will pay?
I was
No installment, Mr. Bhattacharya.
There is another point. Kindly see the divisional application. I am the last person to refer this, but kindly see the prayer. Since my learned senior friend is appearing,
What is the
kindly
prayer?
see the prayer, peculiar prayer in the divisional application.
Let us forget about the prayer. Yes,
No,
Mr. Bhattacharya, how soon?
They are not asking, they are not challenging that order. They are asking for declaration from your lordship as a tenant. And the
No,
subtenant.
that I think Mr. Bhattacharya will not press. That is the advocate on records drafting. I think Mr. Bhattacharya will not press.
And who has affirmed the epidemic? The subtenant. The tenant is not before your lordship.
Rajesh Kumar Chamaria is
not
related to Amit Kumar Chamaria.
No.
I also thought that.
Yes, Mr. Bhattacharya.
Kindly give me 7 days time.
Ruhi Agarwal. Ruhi Agarwal is the judgment date.
No, I do not know deposit payment. Only the time.
The order, yes.
Whatever the order.
Order, may not kindly see. There is no indication in the last page.
Mr. Bhattacharya, if you raise those points, then I think.
I know that. I was telling my learned
started. Give me some time. I will pay.
Ruhi Agarwal is the
I know
judgment
that.
date. And
I know.
affidavit has
Then
been
it shows that the reason why you did not pay 5 installments.
I know that.
Yes. How soon you will pay? Today we are on 24th. How many hours? Not days.
Okay. Kindly give that amount of latitude.
They will pay that.
Hours.
Not hours.
You have got so many.
7 days. I told you, lordship. 7 days.
7 days into 24. How much hours it comes?
Excluding Saturday, Sunday. That I can.
Yes, Mr. Rai.
Then who has affirmed the affidavit? The judgment date is not before your lordship. This subtenant has affirmed the affidavit.
Take this point. You have a better case in that.
Let
take all these points.
If at all they pay, they will pay directly to the opposite party, degree holder.
No, I am not interfering with the order. What is there? I am only extending the time. So today we are on 24th. So by 30th of April.
But in the meantime, 26th order they have to challenge.
Sir, unnecessarily, without challenging, they will challenge that. The same effect, it will be of the same effect.
Then let them pay directly to the degree holder, opposite party.
No, I'm not modifying. I'm not modifying. I'm only extending the time.
Yes. No.
If you say so, then you have to challenge that order, because that order, I'm not saying anything. I'm only extending the time. Whatever was that, if it was to the decree holder, it is to the decree holder. If it is to be deposited, it is to be deposited.
Be paid. Saying to whom it will be paid.
The manner it has been directed.
Yes.
Nothing has been directed. You will kindly see that.
Law is settled, sir. It has to be deposited.
That is the difficulty, Mr. Bhattacharya, whom you do not know whom to pay.
No, by bank draft. By bank draft in the name of the respondent.
It's already name of the respondent.
Kindly indicate that. Kindly indicate that for the.
No, it has been indicated, Mr. Asif.
Yes. Penultimate paragraph of the order impugned. It is further made clear that the stay order that is being granted
in the name of the respondent.
Yes.
And you are saying you do not know whom to pay.
No, I only say, Milord, that kindly see.
Already provided.
Kindly see, Milord, it is further made clear that, Milord, before that.
Yes.
Current occupational charges for the month is to be paid within such and such, and the appellant shall go on paying the occupational charge within 15th of each subsequent.
There it has not been stated. Next paragraph is clear.
Stated. Obviously, with
next paragraph it is clear.
Respondent.
I say, Milord, only think kindly.
It seems, Mr. Bhattacharya, your junior instructed your client not to pay.
No. This is incorrect. No. He is only
in technical points.
No. I told him yesterday that I will not be taking these points.
Subject to result of the appeal.
So close your left ear. Please hear everything from your right ear. Don't hear anything from your left.
No.
Yes.
Milord, kindly indicate me. Kindly give me.
Indication is there, Mr. Bhattacharya. Penultimate paragraph. Bank draft in the. I'm not changing anything.
Bank draft in favor of whom?
Respondent. In the title appeal, it has been made.
Bank draft can be made in respect of one person. But
how many respondents are there?
Santosh Agarwal.
How many respondents are there?
Respondent. Santosh Agarwal.
Very well. I will make a demand draft in favor of Santosh Agarwal.
No. He is the sole respondent.
He is the sole respondent.
I will make that.
Your junior has some other instructions.
If they don't want to pay, let them.
Payment cannot pay. It has to be deposited.
But
He
he is taking a point which if I take before my lords, then your lordship will be indicating that I have to hear out the matter on merit.
Then I have to hear out.
Know that.
Then I have to hear out.
Then I will
If
raise
you
our
say no, it has not been indicated, it cannot be paid, it is to be, then you are challenging this order, then I will have to hear it.
Lord, your lordship is only extending the time without going into the merits of the order.
Mr. Bhattacharyya, you are creature of instructions. Please take complete instructions. Otherwise, something may be said against you. Please take a complete. If you want to challenge, I can hear you on merits on that.
No, I know that I will be facing that. I say, my lord, your lordship is extending the time only to make payment.
Provided your prayer is to extend.
Yes.
Nothing more than that.
Nothing more than that. But my right, if I am aggrieved with the order.
Yes. How can I then challenge? Because I am extending this. You cannot challenge this order. Mr. Bhattacharyya, please make up your mind. If you want to challenge, you have to make submissions on merit. Because once I extend, then you know better whether you cannot challenge that order.
And if it is challenged, then I will raise the other points.
Yes.
You are asking for declaration from your lordship that I am a tenant. Kindly see the prayer at page 26. I don't know, sorry to say, my lord, who has drafted this.
Mr. Bhattacharyya, do one thing. Hold conference during the recess. Come back after 2.
Then
take complete instructions
then
because
Friday, tomorrow, kindly
Why?
take up.
At 2,
after recess, my lord, I have got some
after recess, not immediately after recess, there will be some original side matters. Thereafter, I will be taking.
Okay, okay.
You will get some time.
Okay.
But I'm seeking one brief, urgent matter. This honorable court protected the demolition for some time since the building tribunal was not functioning. Immediately thereafter, when the building tribunal made function, I filed an application put up that here my application for stay. That is fixed on 30th.
Yes.
That revisional application, I'm not, that interim order expires. I filed.
When interim order
it expires in end of December.
Yes.
I took endeavor but could not able to list the matter.
File the application, it will be listed, Mr. Mukherjee.
I want only a protection up to 30th.
File the application, it will be listed.
Without your lordship's leave, the department, this will come up after 30th, then it will become infraction. I want protection only up to 30th. 30th, I will try my life.
Mukherjee, your client could wait from December till April.
By that time, the tribunal made functioning. That's why I approached the tribunal. Tribunal took up my put-up petition and fixed it on 30th.
When the put-up petition was taken up?
16th.
16th, and today we are on 24th.
30th is the date fixed, I want only.
That is why you have chosen 24th as the date.
I want this 4 days protection so that I can try my luck before the tribunal. Ultimately,
who is for the opposite party?
At that junction, nobody appeared, but I will serve the KMC authority and come back before you.
All right, file tomorrow. Application. File.
Very embarrassing. Item number.
If it is embarrassing, please don't mention.
I was done.
File an application.
My lord, I did item number 32, just was outside, all the matters got called on lordship.
You enjoyed the conversation outside.
My lord, thereafter the conversations have not been.
I was not privy to those conversations.
My lord will kindly restore that 36.
32.
36.
36 to restore.
Great.
Final side list, item number 1.
None appears for the petitioner at the time of call. Same order. Next.
Item number 3.
Same order. Item number 3.
For the respondent.
তো ওইটাকে লিখে দিন ওই none appears for the petitioner at the time of call. No accommodation has been paid for either. The opposite part, the respondents are respondent number 1 is however represented by the learned advocate. Full stop. For the ends of justice, the hearing of the matter stands adjourned.
May I file my affidavit?
Affidavit in opposition filed by the respondent number 1 is taken on record. তারপরে তাহলে লিখবেন for the ends of
Sir,
justice.
kindly extend the time, my lord, till today for filing.
After? Yes, Mr. Chatterjee, so it will appear after 3 weeks. তাহলে ঠিক আছে তাহলে this matter after তাহলে আগের গুলো তাই করে দেবো this matter after 3 আগের গুলো তাই. Yes, next.
Item number 4.
But I appear for the OP number 1, my lord.
I appear on behalf of the petitioner. My lord, we've been served with the opposition on Saturday, 19th of April. I'm praying for an extension of 3 weeks to file reply in both matters.
Opposition was served on 18th of March 2025.
The respondent number 2 has filed.
March, but I have the service copy.
The respondent number 2 has filed their opposition on 19th April. The respondent number 1 has served us on 18 March. Kindly grant 3 weeks time. We'll file reply in both the opposition.
For the
1, my lord. But may I only file my affidavit in opposition in court?
The affidavit in opposition. There also extension of time is necessary.
My lord, I had extended my time on the last occasion, my lord.
It's within the extended time. The affidavit in opposition filed by the respondent number 1. Why so many volumes?
Not the entire details, but the annexures, my lord.
The affidavit in opposition filed by the respondent number 1 is taken on record. First of the learned advocate appearing for the petitioner submits that on 19th of April,
19th of April, the respondent number 2.
The respondent number 2 has served a copy of the affidavit in opposition upon the learned advocate on record of the petitioner. First up, in view thereof, the learned advocate appearing for the petitioner prays for extension of time to file extension of time to file the affidavit in reply by 2 weeks. First up, on the prayer of the learned advocate for the petitioner, time to file the affidavit in reply is extended by 2 weeks from date. List this matter after 3 weeks.
Grateful.
Number 5.
5. None appears for the petitioner. Same order.
Number 6.
6. Same order.
My lord, I am for the petitioner. I am seeking for short passover, only 5 minutes passover.
The learned advocate appearing for the petitioner prays for next.
Item number 8.
Item number 10.
8. None appear. Yes.
This is my application under clause 13. This suit TS 147 is suit for permanent injunction. Lord, pending since 2021. Lord, will kindly takes how this suit has panned out, my lord.
Suit filed in December 2021 for permanent injunction. Thereafter,
what is the ground for transfer?
Yes, Milord will straight away then take paragraph 60.
60
of my pleadings, Milord.
Why such a longish application under clause 13?
That is because of the background of the suit and how orders have been passed in different applications. Paragraph 60.
Already you serve a copy. Serve a copy. This is appearing for the first time.
No, Milord. Milord, we have served. Lordship
This is appearing.
This had appeared before His Lordship Justice Raja Basu Chaudhary twice.
Now it's a change of none appeared.
None appeared.
So can you
although in different applications of the same plaintiff, different persons are appearing. Will kindly takes the orders.
Please serve a notice upon the learned advocate before the
trial court.
Trial court meaning thereby in Uluberia court. It's in Uluberia court.
Yes.
The proceedings is pending in Uluberia court.
Yes.
Please serve there. So the rule has been served.
Eight and 9.
Yes.
An
What-
affidavit. And we will file an affidavit.
You want to file an affidavit? So 1 to 4. What about others?
Others haven't given Vogalat,
All are your brothers, I think.
but only Vakalatnama has given by 1 to 4, 6, 8 and 9.
5, 7 and 10.
4, 6, 8 and 9.
1, 2, 4, 6, 8 and 9.
Please mention in.
I must apprise your Lordship, 5, 7 and 10 are defendants in the trial court also. They have never appeared. We have taken substituted service order under Order 5 Rule 20. Despite that, publication made, but nobody is appearing.
What is the order passed on that substituted service?
Look,
Any
for 5,
finding-
7 and 10, we had
5, 7 and 10.
Yes.
So
The
if
order
service
was
recorded satisfactory, but after transfer, if it is transferred, then they have to be
that
then
we
entitled
shall.
to.
That we shall.
All right, later appear Ashun. The learned
Grateful, my lord.
Number 9, this. Number 9.
None appears.
Please, your lordship. This is a petition for transfer under clause 13 of the latest patent. On the last occasion, the lordship has issued the rule, 6th of March 2025.
You are appearing.
Friend is appearing. And also the grievance is that
I
am appearing for the grievance of the petitioner. Why I have filed this application is that 4 orders of High Court are there for expeditious disposal of the suit. The suit is of 2008 specific performance. Only till date the evidence action of the PW2 has started.
Is it a ground for transfer?
It is not a ground for transfer, but there are 4 High Court orders. 4 High Court orders.
Is it a ground for transfer?
This must be a valid ground. Why your lordship is pending from 2008. The suit is not proceeded with at all. Only the plaintiff number 2 witness has started action after so many 17 years. Your lordship will kindly.
No, that is why I am asking you. Is it a ground for transfer?
Is
repeated directions for expeditious hearing not complied with? Is it a ground for transfer?
One of the ground, your lordship, why the court below is not competent enough to proceed with the hearing of the suit at all. Your lordship, the fact is that we have been making
order sheets are produced. It will go.
No, I have annexed everything.
So,
your lordship, I have made 5 petitions for preponement of the date of hearing on the basis of High Court orders. The lower court is not listening to that.
Yes, what is the submission?
Not listening to that.
For the respondent number 1.
I appear for respondent.
You are respondent.
Pro forma respondent led by.
How many respondents are there?
2 respondents and there are several pro forma respondents.
Respondents are there for whom my learned friend is appearing, Mr. Moinuddin.
27 to 90.
I appear for Pawan project.
Pawan projects.
Pawan project. That's it. Lordship, kindly consider we have no objection to appear before your lordship. We have no difficulty if the matter is taken up and your lordship transfers the suit from the Barashat to this court.
No.
Lordship, I am led by senior advocate
pending specific performance of contract,
2008.
which is pending before Barasat court. I appeared in connection with the civil division.
Lordship, we have no difficulty if your lordship considers and passes order.
Lordship,
we have no.
Looked at the cost title.
Lordship, I believe my learned friend also has no objection.
No.
Lordship,
I have objection. Several objections. Since I am not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be placed before the Honorable Chief Justice for necessary orders.
Lordship,
I appeared in civil division application. I appeared in first miscellaneous appeal. So I was led by Mr. Rai Chaudhary and Mr. Rai Chaudhary.
Your lordship is aware. That's why your lordship knows it very well why the suit is not proceeding. Your lordship, since your lordship asked this question as to whether this is a ground, I was tempted to cite an order of Justice Rumapal that this is a very valid ground. If the lower court is not proceeding with this suit, there are several High Court orders.
Now,
the better court for.
No, I am withdrawing my observations because.
but Malad, this court was the best court.
The cost title. Otherwise, Mr. Rai is appearing.
I was. If Malad grants me leave, Malad what?
He appeared against us when I was at the bar in this matter, many proceedings.
Malad, but what to do, Malad? We lost the best court.
No. Yes,
Malad knows. Such is the situation.
But you are appearing for whom?
I am appearing for respondent numbers, Malad, 27 to 96.
But give your appearances. So. Yes, next.
So this is, may I please your lordship? May I please your lordship?
Yes.
This is a suit. We got an eviction decree on 4th July 2023. Now, while I went to execute the decree,
first time.
No, it is appearing for the first time before your lordship. Lordship, rule has to be issued.
Rule has been issued.
Rule has not been issued. Rule has not been issued. Rule has not been issued. Let your lordship issue rule. Your lordship, issue the rule. That's the first prayer.
Yes.
Your lordship, this is a case where your lordship, after getting a decree, a sister concern of the judgment debtor has now come up with an application under Order 21, Rule 101.
Saying that the trouble starts after.
Trouble starts after getting the decree. Yes, that is the difficulty which I am facing. For 1 year and the matter is not being proceeded with before the court below from 2023, October 2023. And they are also not depositing occupational charges. And the
learned advocate Yes.
My lord, may I be permitted to one appellate side matter, my lord? Item number 9 has been dismissed for default today.
Item number?
9.
What can be done? You are not present.
My lord, I am praying for recalling for restoration. Recalling the order for restoration.
Yeah, item number 9 ta ke niye the?
Yes.
আনি নিন না হয়ে যাবে।
9.
Please wait, please wait. What is this matter?
Premises tenancy matter, my lord. Petitioner paying rents, my lord, every year. My lord, in the meantime, while paying rent without informing petitioner, my lord, the son of the.
Where is your brief?
I am taking it, my lord.
Give me your brief. Brief is outside, and you are mentioning here. আচ্ছা এটা দেখে নিন তারপরে ওটা ডাকবেন ফাইলটা নিয়ে নিন yes call the next matter you have got now yes
My lord.
who are you in the suit?
I am the, my lord, defendant petitioner, my lord.
You are the
defendant petitioner.
What is the suit for?
Suit for, my lord. Suit for other suit, my lord. Other suit for eviction.
Suit for eviction. West Bengal Premises Tenancy Act. What is the order impugned?
Order impugned, that is, my lord, 28.
What is the nature of the order?
Nature of the order, my lord, petitioner has been directed, my lord, directed to pay. I am coming to. Petitioner is directed to pay 70,424 rupees as default rent. But petitioner has been paid the said amount. Now, my lord, the present, my lord, is the opposite party. Present opposite party. My lord, CS Dakhayani purchased the said property in the.
So that is a different thing altogether. You are challenging an order passed under section 7(2).
Yes, sir.
Directing you to pay the amount.
Yes, my lord. But in the learned court, my lord, everything was produced before the learned court. That the petitioner, that the plaintiff has no right to claim the previous rent. Petitioner, plaintiff purchased the property in the year 2021, but he demanded the rent of 2017 to 2021. Already petitioner.
Why they are not entitled to claim rent? Do you have any decision in support of your that contention?
My lord, after
there are reported decisions.
Yes,
have you brought that?
I have no decisions, no letter of acknowledgement.
There are decisions in your support. You have not brought that.
No letter of acknowledgement issue.
Sir, I'm asking you.
That I have purchased the said plot and this time. But only when a petitioner came to know, petitioner was in.
Have you got the.
On 23rd July 2021.
To raise that point in the application under section 7(2).
Yes, madam.
Place that paragraph where you have raised that point.
My lord, that copy is not with me, my lord.
Copy is not with you.
My lord, fix it, my lord, as a day, my lord. I only to restore it today. Yesterday, today.
Only restoration.
Restoration and as you will receive me.
Tomorrow.
Petitioners, my lord. Petitioner, elder brother tried his turn. Petitioner went.
Petitioner's elder brother tried. He is also a party.
No,
in the suit, not a party.
He went to his.
Not today. Order record করে দিন তাহলে on the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned for the day. Stands
next week.
Stands adjourned. Yes.
It will be appear next week.
Let us see where it appears. It has been adjourned for today.
Not tomorrow, my lord.
Not tomorrow.
Not this.
All right. Accepted. Yes, next.
41. Lord, I should
I give an appreciation to my learned junior. He only showed me para 9.
He could convince you. He could convince you.
Yes.
To argue on merits.
No. I say this thing that only see page 55.
Page 55 of the revision application.
Of the revisional application.
Yes.
This is an order of the Supreme Court, and kindly see same landlord against whom wherein my lord I have the instructions that your lordship may permit me to deposit.
Paragraph 9.
Paragraph 9.
Page 55.
Page 55, paragraph.
Para 9. Para 9, page 55. And the order has also been annexed. The petitioner and other tenants of the building, including Bank of Rajasthan, will not pay any rent to the 11th respondent who is the landlord, but will deposit the same with Registrar General of the High Court at Calcutta from month to month on or before 10th of month of each succeeding month, and the 11th respondent is restrained by any order of injunction from this court for recovering or realizing any rent or compensation from the tenants or occupants of the building.
So what was this suit for, Mr. Vadajaji? What was the dispute there?
This is a proceeding. This is a proceeding.
Proceeding between.
Will kindly see page 54.
Yes, what is the, I'm asking you.
This
Because
is a
the
proceeding, Miller.
Xerox copy is very small. This. What is the proceeding
The
for?
proceeding is that, Miller, there is an illegal construction.
I'm telling you.
Persons are also occupying.
Please take your seat.
Occupying.
Let Mr. Vadajaji exhaust. Yes.
I say, Miller, kindly see only one paragraph.
Yes.
I'm just reading. Your lordship may kindly, Miller, hear it out. Respondent 11 raised a construction at 174.
Respondent 11 is the
person to whom the deposit has to be made.
Has to be made. Yes.
Which, according to the municipal authorities, was unauthorized. The municipal authorities therefore issued a notice under section 416 of the Calcutta Municipal Corporation Act 1951 to the owner as well as the occupier of the said building to show cause as to why the unauthorized structure should not be demolished. In the meantime, the municipal authorities also posted guards at the site to ensure that there was no further unauthorized construction. Thereupon, respondent number 11, the owner of the building, filed title suit number such and such, challenging the validity of the notice on a number of grounds, and secured an interim ex parte injunction restraining the corporation from interfering with the construction work. Under the protection of the said interim order, the activity of the construction was carried on. Subsequently, on 30th of January 1978, the municipal authorities issued a notice under section 1 of 414 of the Act for demolition of the unauthorized construction. Efforts were made to serve this notice on respondent number 11, but it is alleged that he was trying to evade service, and as such, the notice had to be ultimately posted at the site. The Deputy Commissioner of the Calcutta Municipal Corporation took up the hearing of the case and directed demolition of unauthorized construction. Then, my lord, this matter went on, and my lord, it appears, my lord, that in paragraph 9 of this order, there are directions which has to be complied with from paragraph 9 onwards. Therefore, the matter is pending before the Supreme Court, and now, my lord, I think, subject to correction, but your lordship, my lord, directs, my lord, that I will be in contempt.
Payment, I will deposit.
You have filed an application for stay.
I have filed an application. Yes.
You have filed an application for stay in the appeal.
Appeal.
They have filed an application for payment of occupation charges.
They are opposing.
You have filed any objection to such application?
My lord, I cannot make any. I should not make a. Because, my lord,
show me that you have taken this point before the learned trial judge.
Which point, my lord?
Show me that you have taken this point. You have raised this objection that for such and such reason you cannot pay, and tell me how much amount you have paid on account of this rent you have deposited pursuant to the order of the Honorable Supreme Court. Show me that.
What I find from the order, this I
Yes,
should
I'm
be,
asking you.
I-
Facts you know.
Yes.
Mr. Bhattacharya, there are two things. It's a demolition, it's a proceeding for demolition of an
Right.
unauthorized construction.
Right.
So there, in order to protect the interest of the tenants, so they were directed that you will not pay to the landlord, please deposit. That was the decision.
Right.
Show me how much amount you have deposited, how much amount you have paid. Show me the positive averment of your client, how much you have paid for occupying that property.
for occupying the property.
Yes, yes.
If I want to enjoy this stay, subject to result of the appeal. আমি deposit করতে চাইছি। That is the law. Apart from
This is one. Second is, a more vital part is that
You know,
it has
as
been
it
vacated.
appears from the
This is
order.
a subsequent order. This is not
Yes,
under challenge.
Yes.
So you challenge, that will be considered thereafter. On that, this, because subsequently it has changed. So now this order is staring at your face. Unless you challenge, you are not entitled to any order now.
No, I only say one thing, Millard, whatever. Millard, I think, Millard, if your lordship permits me to deposit this amount without prejudice to my right,
That will be interfering with the order.
This will
So,
not
Bhattacharya, I cannot touch that order.
No.
Only extension subject to hearing Mr. Rai, I will consider that. But if I have to interfere, then I have to go decide on merits.
Your lordship is not, I am saying.
Now,
Millard,
after this order, I cannot touch this because there is that order has lost its force.
Millard, I say, Millard, I can be permitted to raise the point of this deposit. Otherwise, I will be in contempt. Kindly see, Millard, I say, Millard, the order of the Supreme Court. If your lordship directs me to deposit within 7
Bhattacharya,
days.
the conditional order
Yes,
has been
yes.
vacated by this order.
Yes.
You have to challenge this order. First challenge this order.
No, I say, Millard,
Because the subsequent event has cropped up. It has been vacated. Now there is this order. Mr. Bhattacharya, this order has lost its force now. It has been vacated.
Now, Millard, I say, Millard, with the deepest of respect, Millard, lordships have got the powers or the superintending powers that
You have
Millard
to
can
challenge
be
this.
exercised.
You have to challenge this order, Mr.
No,
Bhattacharya.
I only say, Millard, that having regard to what peculiar facts of the circumstances.
Yes,
of
take
the
all
case.
these points. Challenge this order. Challenge this order.
But Millard,
Take all available points. But challenge this order first. Without challenging, I cannot, because Mr. Bhattacharya, this order which you are now challenging has lost its force. Mr. Rai was taking this objection from the very, I asked him, what will be the use if I only extend? Now, if I have to interfere in what merits, I cannot.
Your
Because
lordship is not
that
going into
conditional
the
order is no
merits.
more in existence.
Your lordship is not going into the merits, only your lordship is extending the order by only adding one line. No, only one line.
One line or one word.
Deposit
Mr.
this
Bhattacharya,
amount.
it's not that one line or two line or one word. The effect of that is what is to be considered. If the effect is, Mr. Bhattacharya, it's from your end to pay occupation charges.
Yes, that and duty bound.
From your end.
Yes.
But from their end, whether they are entitled to that or it is to be deposited.
Yeah, no.
So they can have, they can make their submissions on that. So I have to go on merits. I have to hear them on merits also. You may say, yes, I have to deposit, I have to pay, I will pay.
Yes.
I am depositing. Don't pay to him. So his right under the order is being affected if I add one sentence or one line.
Would your lordship, Millard, I say, Millard, this is only it is only, Millard, a submissions from the bar, that if your lordship permits me to
modification application.
to make the payment before the Registrar General of this Honorable Court.
Mr. Bhattacharya, I cannot modify. To modify that order, I have to please challenge this order then. Then I will consider whether to the Registrar General or to where, that I will consider. That I will consider. And it is also to be considered now whether you are trying to enlarge the scope of the application or the order which was passed by the learned appellate court, because there subject to correction, these points were not raised. So you are making out a totally new case before the revisional court, whether that is permissible. Whether that is permissible.
Appellate court had a modification application. If that will be drafted plus.
Kindly give us that liberty at least so that we.
What liberty?
Raise these points before the landed court below.
Appellate court.
Before the appellate court. Before the appellate court.
What?
For modification, by filing a modification application, because these are matters on record.
Some these
I understand.
not modified.
Yes.
Then you have to challenge this. On this, after this, I cannot add because this has been modified. And this is not under challenge.
Therefore, that initial order, Milord, has lost its force.
Has lost its force. That was the initial submission of Mr. Rai. I asked him to keep quiet. But now, if you want to go to the merits, then this point is staring, this order is staring at your face.
Permit me, Milord, to challenge this order. Otherwise, I know, Milord, I will be suffering. At least at the end of the day, I am answerable to the, because when I read the brief,
I'm not saying anything more now.
I know what will be the answer from my lords. This is the difficulty, and this is all the more difficulty when, supposing my learned junior was saying that supposing in a very disciplinary proceeding matter, a very complicated matter comes to me, I always visit you and I take your suggestion. But before a matter is being drafted, before a matter is being made, prepared, at least something what has to go into the petition must be consulted. There is no, Milord, I have got no hesitation to say, Milord, in the open court, that in many matters, in many civil matters, I ask the opinion of your lordships. There is no end of learning. No. There is no, Milord, there is nothing to get.
After some argument, बेटा लिखें नहीं कौन साढ़े तीन yes
163 monthly list.
none appears for the petitioner at the time of call. No accommodation has been sought.
Petitioner before your lordship is a tenant.
Is that?
Is a tenant.
The defendant is the petitioner.
Tenant here there.
Defendant in the suit. Yes.
He prays for some repairment of his shop.
Repairing the shop.
Shop room, by the way.
Yes.
Tenanted shop room.
Yes.
That petition was dismissed. My lord may come to order at page.
What is the stage of the suit?
It is the initial stage. There is a two suits are there. One is instituted myself for declaration in injunction for wrongful defending myself from wrongful eviction, and they have instituted this. My lord, pertaining portion is at page 20.
What is the item of repairing?
Item of repairing is a roof.
Where have you stated that?
My lord may come.
You have not specified anything.
15, page 15.
Page
15.
Yes.
Page 15. That pertinent portion is the page 2 of the 16 page. That the roof structure as well as the tiles of the roofs and the plastering of the wall of the shoot premises got very much damage and repairment is necessitated. In 2000.
But you have not paid for any local inspection. Without ascertaining that, how can this application be filed?
My lord, that is totally dilapidated. It is
that has to, that picture has to come before the court
for ascertaining.
Yes.
My lord, local inspection can allow the petitioner to make
None appears for the petitioner at the time of call. No accommodation has been sought for either.
Out of Kolkata.
On the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned.
167.
So I have petition, Lordship. This is a non-payment of gratuity matter, Lordship. As a controlling authority, there was a in the impugned order is page number 113, Lordship.
113. Yes.
Yes, Lordship. May I read out, Lordship?
Yes, who are you?
I'm for the petitioner, Lordship.
No, petitioner, I understand. Yes, you are the certificate holder. Yes. What
Yes.
do
They are not till date, they are not even paying the amount. They delaying the proceeding, Lordship. They even the certificate was issued, Lordship.
Yes. So take steps for execution of that.
They
Why have you filed this application under Article 227? Are you challenging this order?
Yes, Lordship.
Why?
There need to be.
It's in your favor.
Lordship, I am new in this matter, Lordship. I need to be prepared, Lordship, in this matter. Kindly give me one more week, Lordship.
On the prayer of the learned advocate for the petitioner, hearing of the matter.
168.
None appears for the petitioner at the time of call. No accommodation has been sought for either. Yes, next.
169.
Yes,
For
Mr.
the petition, this is an application under section 24 of the Code of Civil Procedure.
Transfer.
Transfer.
You are the wife.
Husband. I have filed.
You are the husband. Why?
There are two proceedings. One is running at Chandannagar and other is running at Barakpur. Two proceedings.
One is at Chandannagar, other is at
Barakpur.
Barakpur. So one instituted by the husband, other by the wife.
Wife claiming alimony under section 18 and 20 Hindu Adoption and Maintenance Act at Barakpur. Husband filed.
Which is the earlier proceeding? Husband's proceeding, you are appearing for the wife.
Not me, my lord. Mr. Tulsidas Ray appearing for the opposite part. He is in court number 238, my lord. Ponji matter.
Number?
238. Ponji matter, my lord.
Ponzi matter.
Yes.
So your suit is under what provision?
Chandannagar.
No, under what provision? Your suit is for what? Your suit is for dissolution of marriage.
Dissolution of marriage.
And the wife's suit is for?
Section 18 and 20 of Hindu Adoption and Maintenance Act.
Hindu Adoption and Maintenance Act. Why?
Filed at Barakpur.
No, so why do you want transfer of this? You contest there.
Two proceedings. I want two proceedings.
Different
Maybe
nature.
under any of the one court, either Chandannagar or Barakpur. Two proceedings may be hard. Another.
So you go to Chandannagar. It's better.
I have filed Chandannagar.
So you go to Barakpur then.
I am ready. Both
Take
the
the-
proceedings may be heard in one place.
That, but Hindu Adoption and Maintenance Act and this divorce, how these two are related? What for? Why? Because
one after
why? Issues are different, everything is different.
two proceedings are running to different places. Well, maybe hard one in one place.
Where is he? Can he come?
No, my lord, 238, he's engaging in.
He's agreeing to, you have not paid for transfer, he wants
My lord,
transfer.
kindly fix a date, my lord.
Asun. Mr. Banerjee, learned advocate, appears.
Same man.
170, yes.
Same party. Same party. These
Same
two-
parties?
Same party.
Oh, here what do you want?
Here against the order passed by the Bagpur court, interim alimony, ad interim alimony.
20,000?
30,000. 20,000 for a wife, 1,000 for child.
10,000 for the child.
10,000.
20,000
30,000
for the
20,000 for the wife.
10,000 for
For
the
the child. 30,000.
Mr. Banerjee, pay to your wife and child.
My husband is earning 70,000.
Not your husband. You are the husband. Husband is earning how much?
70,000. Filed affidavit, my lord, page 34. 33. Affidavit filed.
All right, so he wants time, so
71,766. Aged father, mother, and EMI for the purpose of loan for the purchase of flat, which is used by the wife.
Mr. Banerjee, learned advocate, appears for the petitioner.
Eviction. Defendant tenant is the petitioner before your lordship, challenging an order whereby the defendant's application under Order 39 Rule 7 was dismissed without assigning any reasons, only on the ground that in my shoot, earlier shoot, for declaration of tenancy, there is an inspection being made. But my shoot is different cause of action, and the tenants.
Why you paid for local inspection?
But to ascertain the reasonable requirement, alternative accommodation.
You are the defendant.
I'm the defendant tenant.
For
Plaintiff-
ascertaining the
Plaintiff has,
alternative,
yes, plaintiff has alternative accommodation.
plaintiff has alternative accommodation.
Yes.
Where have you stated that?
My lord, may
In
kindly,
the in your pleadings?
my lord, kindly see Order 39 Rule 7.
No. In the written statement, show me where have you specified the alternative accommodation in your pleadings?
Page 28.
Yes, page 22. Which
My lord.
paragraph?
My lord, paragraph 11.
Paragraph 11. Is that page 24?
Page 31.
31.
Page 31. Internal page 4. That is my written statement. Amended written
Yes,
statement.
internal page 4. There
Internal
is no paragraph 11 in page 31.
paragraph, sorry, paragraph 19. Sorry, paragraph 19. 18, 19. Paragraph 18, therefore, it is paragraph 19. That he also have a, this is in relation to a shop room.
Where have you stated that where is the alternative accommodation? Where have you stated it here?
My lord, kindly see end of page 4. নালিশি প্রেমিসেসের অবস্থিত দোকানটি ওয়েস্ট বেঙ্গল শপ and in the end of paragraph end of page internal page 4 page 31.
Yes.
রেজিস্ট্রেশন প্রাপ্ত হয়েছে বিবিধি নিশিকান্ত দাস নালিশি প্রেমিসেসে মায়ের নালিশি প্রেমিসেসে ঠিক ওপরে দ্বিতল পোর্শনের বাবদ ভাড়া টাকা সালের মধ্যভাগ হইতে এত সালে ফেব্রুয়ারি মার্চ পর্যন্ত ইংলিশ মাস অবধি আপোষ মালিক তথা বাদী নিত্যগোপাল দাসের অনুকূলে প্রদান করেন। But this is the accommodation which I say.
This is with regard to the payment of rent.
Payment of rent. This, my lord, is in possession in my dispute submission in favor of the plaintiff. Vacant position. পরবর্তী সময় এত মাস সালে নালিশি প্রেমিসেস মায়ের নালিশি প্রেমিসের উপরে দ্বিতল প্রেমিসের ভাড়া বাবদ, but that has been vacated.
Where have you said so?
If my lord may kindly text my application once.
No. In the pleadings, where have you said so?
My lord may kindly turns to the impugned order once. Kindly comes to the impugned order once. The ground of rejection.
Yes.
Kindly see the ground of rejection. Learned advocate for the plaintiff it starts with.
Yes.
Learned advocate for the plaintiff raises a strong objection against the submission of the defendant on the ground that the defendants want local inspection which is fallen outside the suit premises. He further submits that the instant shoot is running analogously with the title shoot number 349 of 2015, that is my shoot for declaration of my tenancy right, whereby the local inspection has already been done and the report is filed before the court. Therefore, there is no need of local inspection in the instant suit on the ground that the two.
Your suit for what you
for declaration of my tenancy right.
Yes. What were the points of local inspection there?
But that document is not with me. Moreover, the cause of action of the two suits are different.
Maybe. But if the points are same, if you have paid for on this ground.
No, I have never prayed for any.
Show me that. In the earlier application, this is the report. The court says report is there.
But then I will have to come back with that report.
That is one. And show me your application for local inspection here.
My lord may kindly comes to page 46. Page 46. My lord may kindly comes to page 49.
Yes.
Point of local inspection. My lord may kindly skip the kindly come to page 49.
Yes, I am at page 49.
মোট 3টি দাগে 12 শতকের মধ্যে 2.5
49.
Page 49 is the application for local inspection.
Page 48 is the prayer.
Yes.
Yes.
No, this is the grounds of inspection. Point for inspection starts at page 48.
Yes, page 48.
Page 48.
This is the schedule.
This is the schedule. Thereafter, the point of inspection.
Yes.
My lord, may kindly see. উক্ত 2.5 শতক ভূমির উপরিস্থিত ত্রিতল বিল্ডিং এর নিম্নতলে উত্তর পূর্বাংশে কম বেশি 20 ফুট বাই 10 ফুট পরিমাপের এক কামরা দোকান ঘর সহ বঙ্গশিপ বুক
কি অবস্থায় রইয়াছে?
This is the defendant shop room. This is the defendant shop room, which is in my possession.
Yes.
Now kindly see point number 2. নালিশি ত্রিতল বিল্ডিং এর নিচের তলায় নালিশি প্রেমিসেসের লাগোয়া দক্ষিণের দিকে ও পশ্চিমের দিকে 100 কোরিয়া মাইলেজ
জুতোর ব্যবসা চলে।
That is the plaintiff shop room. That is the plaintiff shop room.
Yes.
Now kindly come to point number 4.
Yes.
নালিশি ত্রিতল বিল্ডিং এর দ্বিতীয় তলে এবং তৃতীয় তলে বসবাসের কোনো চিহ্ন রইয়াছে কিনা উক্ত ত্রিতল বিল্ডিং এর
Actually fishing out of evidence.
No, my lord, in my respective submission, whether he has a sufficient accommodation.
Show me first your case that he has sufficient. Those are vacant. Where is the case made out in the pleadings? You are trying to fish out. Let the commissioner go. Let him say, now I will.
Now, may I?
Mr. Bhattaji, this is only for the purpose of this an evidence. This will be an evidence in the suit. First, show me your pleadings in support of that.
So far as
so you are trying to collect evidence by way of local inspection.
My lord, so far as the point number 4 is concerned, my lord, it is on the ground.
Everything is fish out evidence. How, in what condition your property is there.
No, kindly see the next line.
This might be the subject.
Kindly see the next line of point number 4.
Yes.
উক্ত ত্রিতল বিল্ডিং এর দ্বিতীয় তলে এবং তৃতীয় তলে কতগুলি কক্ষ আছে এবং অপর অংশ কি কার্যে ব্যবহৃত হয়েছে।
Out of evidence, you are in that premises. You must know. You have to assert. These are the premises. Then local inspection.
But the ground of rejection is something different. Ground of rejection is that there is an inspection.
I can supply the reasons.
But there is an inspection being held in my shoot.
All right. I will proceed on the basis of this application. These points.
May I come back with the application for my local inspection on my shoot which has been done? May I come back tomorrow? Because that has fallen from your lordship, my lord wants to look into what was the point of local inspection in my shoot for declaration of a tenancy right.
After some argument, the learned advocate appealing for the petitioner placed for an accommodation.
Order 6, Rule 17 for amendment in bringing on record one document that has been transmitted to me at page 28.
Transmitted to you?
Yes. Here he clearly accepts me as a tenant. Kindly see my Pujanio Mama Babu, it refers to the tenant. Now it has been signed by the defendant who is the plaintiff in a suit for declaration of a suit for eviction. পত্র মাধ্যমে আপনার ভক্তিপূর্ণ প্রণাম গ্রহণ করবেন। পরে সমাচারে এই যে বঙ্গশ্রী বুক স্টল ও ঔষধালয় ঘর ভাড়া সংক্রান্ত চুক্তিপত্র নিয়ে আমাদের মানে এভিডেন্স has not started. Should have even the হয়নি তো ইস্যু হয়নি তো issues has not been framed.
The finding is that trial has commenced.
No, my lord. I have instruction to submit that the issues has not been framed. Kindly see. Evidence you will start for evidence of PW1. Evidence has not commenced. My evidence, I am the plaintiff.
Yes, what is the amendment you are seeking?
At page 28. Kindly see the second paragraph, that is vital. বর্তমানে চুক্তির মেয়াদ ব্যাপারটি ছাড়া
No, this is a document. Where is the application for amendment?
Yes, my lord. Page 20. The big petition, my lord. Amendment petition. Page 22. Look at the key petition. Order 39 rule 7 page 20, page. Kindly see the সংশোধন যথা only the letter document, the contents of the document I want to bring by way of amendment very clearly admits me as a tenant in possession. There was a prior paper publication that is not required. Subsequent to the paper, been convinced over the paper publication.
Publication.
No, I am not bringing the paper publication. I am bringing on record the document which has been created by the landlord in favor of the tenant. And expresses desire to sell the property, but that is on the ground of specific performance. I am not on the specific performance. I don't want to change the nature and character from a declaration of tenancy right to a suit for specific performance.
Suit for?
It is a suit for declaration of my tenancy right. Now the court proceeded by way of amendment. I want to change the nature and character from declaration to a specific performance, suit for specific performance.
Yes, rightly so.
No, that in my respective submission, kindly.
Why do you want to incorporate this?
Kindly see the contents of the letter. Contents of the letter, in one way, if your lordship reads it, then it will be a suit for specific performance. But in the other way, if your lordship looks into, then it will be in the nature that the landlord accepts me as a tenant. Malan, may kindly see the second paragraph.
Yes, yes.
Kindly see the second paragraph.
Page 28.
What? Page 28.
Second paragraph of what?
Page 28.
No, 28 is the document. So while considering an application for amendment, that will be looked into.
But only for the purpose of I want to bring into this document.
All right, I will follow that principle in all applications under Order 6 Rule 17.
So far,
the merits of the amendment,
credibility of the document will be looked into by at the time of evidence.
Of the amendment, the law is merits of the amendment cannot be considered. I cannot look into.
I am not inviting a lordship.
From this, it appears that you are trying to change and
contents. Prima facie, kindly see the contents.
Contents of what? That document.
Particular document.
Page 28, I will not look into page 28 at all.
No,
I will only look into this.
Tyler, may kindly see my application for amendment?
Yes, yes, I am at page 21. The schedule of amendment.
Page 21.
Yes.
বর্ণনাপত্র পঞ্চম পৃষ্ঠ নবম লাইনে প্রাপ্ত হইতেন কথাটির পর নিম্নলিখিত কথাগুলি বসিবে গত ইংরেজি এত তারিখে বর্তমান নামিত দৈনিক সংবাদপত্রে ভারী ভাড়া আইন বদলাতে কেন্দ্রীয় উদ্যোগী দুশ্চিন্তায় ভাড়াটিয়ারা বিষয়টি উল্লিখিত হইয়াছিল। বিবাদী নিত্যগোপাল দাস উক্ত 4/7/2011 তারিখে বর্তমান সংবাদপত্রের উক্ত পাতাটি জেরক্স করিয়া উক্ত ইংরেজি 4/7/2011 তারিখে পরে ইংরেজি 2011 সালের জুলাই মাসের মধ্যেই উক্ত বর্তমান দৈনিক সংবাদপত্রের উল্লিখিত পাতাটি জেরক্স সহ বিবাদী নিশিকান্ত দাস নালিশি প্রেমিসেস বিক্রয় করিবার জন্য যে চিঠিটি প্রেরণ করিয়াছিলেন উক্ত চিঠিতে উল্লিখিত আছে যে আপনি যদি নিচের ঘরের অংশটি ক্রয় করতে চান আমি বিক্রয় করতে।
So who is Bibadi?
Bibadi is the landlord.
And who is Nishikanto Das?
The landlord. The landlord. The landlord is writing to the tenant.
Yes. What is the sum and substance of that?
But sum and substance, if it is read into in this way, Malad, it will be apparently it will be that is a super specific performance. But my contention would be before Lordship, Malad.
This application under Article 227 of the Constitution of India is at the instance
There is a previous order.
That is the impugned order.
No, there is a previous order in the suit that both the suit will be heard analogously.
All right. Yes.
Next matter at 3 p.m.
Will I appear on behalf of the respondents?
Yeah.
So, Milord, I believe, Milord, the petitioner still had to make submissions.
But only thing, if you have to kindly give some 5-10 minutes pass over, Mr. Mitra is arguing in other.
Can start, Mr. Mukherjee.
Next matter, if you have to, that is also fixed at 3 p.m. If you have to take some minute.
Next matter. এক উকিলের অনেক কটা মামলা থাকলে এই হয় ওরা চয়েস করতে পারে কিন্তু আগে করে
I prayed before your lordship. I can't, my lord. You can pray before your lordship only.
This happens, Mr. Mukherjee, when an advocate has many matters, he can choose which to move first.
Mr. Mitra has been engaged. 208.
Yes. Any opposite party? There was a direction to serve.
No. My lord, kindly remember this matter, my lord. I have given, my lord, 2 copies of the judgment, my lord. One of the Honorable Supreme Court, another by Justice Supratim Bhattacharya, my lord. Yes, I am telling you. What happened, my lord? I filed a suit for declaration injunction. I've seen. I filed a suit for declaration injunction. Now, in that suit, my lord.
Was it to ask Mr. Mitra to arrive a bit late, Mr. Mukherjee? Mr. Mitra, wrong impression was given to the court by Mr. Mukherjee. He said that you are arguing in another matter, it will take some time to reach this court. That was the impression given.
My lord, I cannot stop Mr. Mukherjee. I don't have that courage.
Yes, তুমিও বললে।
This, which matter you want?
This matter, it will take only 5 minutes. Man.
Yes.
Only
5 minutes for
service, direction for service.
Yes.
Number, I filed a suit for declaration injunction. Declaration that the deed of gift executed by the father of the defendant number 1 is void, as the father of the defendant number 1 has no right to.
Oh, this is that matter, recovery of possession.
Recovery of possession.
You have not prayed for initially.
Yes. Now,
give me the decision. Now it has come.
All those judgment has been given to your lordship. After that, your lordship asked 2 judgment that your lordship.
Yes.
At least for this matter, your lordship, on the last time when your lordship read it, that to refer the larger bench in view of the contradict judgment of justice.
Refer the larger bench.
Your lordship.
Why?
Because
Supreme Court is here.
Another coordinate bench judgment that in the.
Make those submissions for referring. I will consider.
I'm not on that. Well, kindly see. Now, what happened, my lord? Ultimately, court found that, my lord, the father has no right over the property. The father of the defendant number 1 has no right over the property, and said that the deed of gift is void. Now, my lord, in the record of rights, my lord, one question, my lord, their name has been recorded because, my lord, admittedly, I am the owner of.
Mr. Mukherjee, your suit was dismissed on the ground that you did not pray for recovery of possession. So, and in the first appeal, you want to amend this by incorporating the prayer for recovery of possession. Is it not barred?
Now, my lord, if your lordship consider 30, your lordship consider that the specifically fact subsection 5, my lord, if I say the appeal is a continuation of the suit, that has been that.
Mr. Mukherjee, appeal is the continuation of a suit. But Mr. Mukherjee, when the question of limitation comes, you know those line of decisions that ordinarily amendment will relate back to the filing of the suit. But in cases where there is a dispute with regard to the point of limitation, it can be directed. It will take effect from the date of allowing the application for amendment.
Absolutely.
So if that is so let us assume today whether your prayer for recovery is barred, expressly barred.
Your lordship has told that at the time of considering amendment, court should not gone into the merits of the proposed amendment. Now,
Mr. Mukherjee, forget what I have said in the earlier matter. Concentrate in your matter.
So in that judgment also, the court will not. That the court will not gone into the merits of the case, my lord.
Yes, accepted. Court will not go. But limitation Show me.
Kindly visualize the judgment of Justice Bhattacharya, my lord, I have handed over to your lordship. Their same point came up for consideration. The Supreme Court judgment has been considered. Now, the view of Justice Bhattacharya is that even in the second appeal, I can I file an application for amendment. But Supreme Court judgment is against me. That's why I handed over to your lordship on my own. On my own. So my bona fide. Now, next minute, kindly see,
Mr. Mukherjee, if the Supreme Court judgment is against you,
but
which is binding?
Here the Supreme Court. Then, my lord, I will bring the line of judgment. Here, limitation will not come.
All right, bring that.
Kindly give me 2 weeks, my lord. 2 weeks.
Why?
I have to study, my lord. I have given 2 judgment at least.
You have a battery of juniors in your chamber, Mr.
Only
Mukherjee. On the prayer of Mr. Mukherjee, learned advocate for the petitioner,
Preliminary objection,
what preliminary objection?
The interim order has been extended today till 4th of June. Lord, that is also.
Mr. Mukherjee, are you serious about that objection?
Lord,
Have you considered that issue?
Lord, that
Yes, take the preliminary
I am
objection.
prompted to Lord argue this, Lord.
Yes, yes. I know who is insisting you to take this point.
No, Lord,
If you want, Mr. Mukherjee, you can make your preliminary objection. I will decide that. I will decide that.
Before.
You can raise that point. Mr. Mukherjee, I will decide that. It cannot
Mr.
go on for long.
Prompted me to argue before your lordship that is the application.
No, Mr. Mukherjee, I am not stopping you. If you want to raise that preliminary objection, you can. It has to be decided once for all. It cannot go in all matters.
But I understand that. But that
because in one matter, I tell you, on this, 8 or 9 civil division applications were filed.
Lordship.
I decided that civil division application, the cost title was longer than the ordering part.
For the economy,
Good for the lawyers, not for the.
even for the state, court fee পাচ্ছে।
Good for the court.
Court fee পাচ্ছে। Your lordship is stopping the court fee of the state. Oh, ঠিক না।
But only one thing. Let
he is now the.
Yes, yes.
Yes.
Yes, yes. He has to. He has
He is
to.
concerned about the state.
Yes.
এখন বিপদে কোথা থেকে কোথায় চলে আসবে?
Yes, Mr. Mukherjee.
But only thing, Lord, let Mr. Mitro start. I have no objection. But Lord, our reply will come from Mr. Mukherjee, Lord, Mr. Senior Mr. Mukherjee.
One Mr. Mukherjee is before me.
From Lord, Senior Mr. SN Mukherjee, Lord.
He is not present today.
Not. But he can start. But Lord, kindly have to accommodate on the next date.
It will definitely take an hour.
Yes.
Hour.
তুমি 1 ঘন্টা নেবে এত বড় মামলা করবে? 20 জনকে জেতাতে চাইছো?
Yes, Mr. Mitra, start.
কোনো মামলাগুলো ডিলিট করে দাও।
I do not know. That's up to Mr. Mitro. Ask him because they will not make their submissions.
I don't think that I would be required to, my lord, trouble your lordship much.
Yes.
Can't take it up to my lord 4 or 4:30.
Yes.
Kindly take the plaint.
Plaint.
Page 143. Or my lord, for that matter, kindly take up the petition because the order was passed in the order 39 petition. Kindly come to page 157.
That is order 39, rule 1 and 2. Yes.
Lordship will find, my lord, the plaintiff is Diamond Harbour Football Club, Mohestala, South 24 Parganas. Defendant number 1 is my
You are in
lord.
the Costa
Yes.
Yes, yes.
157.
Yes.
Defendant number 1, my lord, 11/1 Shutarkan Street. 2, my lord, is only, my lord, Alipur jurisdiction, 2-3.
Yes.
Now, kindly come to the body of the plaint, my lord, page 159.
Yes.
The petitioner is a football club established in the year 2022. The sole purpose of the petitioner is to upgrade and improve the facilities and infrastructure available for football in West Bengal, etc. Kindly turn the page. Kindly come to paragraph 3. The petitioner with other prestigious tournaments is also participating in Premier Division of Calcutta Football League 2024-25, that is state championship, and is presently among the top contenders for the championship title of the said tournament. The petitioner is also participating in Reliance Foundation Development.
That is the other tournament.
Other tournament.
You are concerned with championship.
That's true. The petitioner is also participating in Reliance Foundation Development League Eastern Region, and there also presently the petitioner is placed at 3rd position after Mohun Bagan Supergiant and East Bengal Football Club. It's pertinent to mention here that after playing equal number of matches, both the petitioner and East Bengal Football Club have scored 8 points each, but to etc. Then kindly come to paragraph 4. That now the said championship, that is the Premier League, said championship in its last leg, and now each and every match is very vital for the teams, as an unfavorable result in a single match can change the fate of that team in the said championship. The petitioner is presently standing within top 2 position in the said championship and has a promising opportunity to be the champion in this session. However, now next, it's important. However, due to tight fixtures of matches of the petitioner, it is most unlikely that the petitioner can compete with the best available team in the said championship. One of the crucial matches in the said championship, which is with presently rank 1 team in the said championship, that is East Bengal, was fixed on 13th February 2020. Was fixed on 13th February 2025. Was 13th February, and the next match of the petitioner in the said championship has been fixed on 18th February 2025. However, next, on 14th February 2025, that is on the next day, the petitioner has to play one of the matches of Reliance Foundation Development League, and another match of I-League 2 session is scheduled on 16th February 2025, which in other means that within a span of 6 days, the petitioner has to play 4 crucial matches. It is needless to say that football is a body contact game, etc. Then kindly come to next paragraph. The petitioner has well in advance intimated the same to the respondent via letter dated 5th January 2025
and requested the respondent to reschedule the match fixed of the petitioner, which were fixed on 13th February 2025 and 18th February 2025. So they wanted rescheduling. I shall come.
When the fixtures are fixed, or the fixtures of this was fixed, of this tournament.
Much after 5th January, but I really, my lord, cannot produce that one.
Much after 5th of January.
It was on 20th of January.
This 13th February and 18th February was fixed after 20th of January.
On 20th of January.
On 20th of January.
Would not have written the letter on 5th of January.
Yes.
I have annexed the document, but my lord,
limited scope.
Yes.
Limited scope.
I have annexed it. I'll kindly come to there later, my lord. Kindly come to page.
You can proceed in your own way. I was
no. Kindly come to key 104. Kindly come to page 202.
This is the letter of 5th of January.
Yes. 5th of January to the Honorary Secretary IFA regarding the remaining matches of the Premier Division of Calcutta Football League 2024. Sir, we hope to reach you in good health. Our remaining matches of the Premier Division of Calcutta Football League 2024 has been scheduled on 13th February 2025 and also on 18th February 2025. We would like to inform you that we have a scheduled match on 14th February 2025 followed by a match on 18th February 2025. 16. Sorry, one of them is for the Reliance Foundation Development League and another one is for our I-League 2 session this year. As the fixture proposed to us states that we will have to play 2 matches within 48 hours of each other, keeping in mind of our existing commitment. We will request if these matches are rescheduled to a date which is sportingly feasible for our team to play and perform to the best of our abilities. So their complaint was 2 matches, 13th February and 14th of February. 13th February,
yes,
is the tournament, and my lord, 14th of February, Reliance Cup.
Yes.
Now, kindly look into this letter. How was it sent? It's not, my lord, found. There is no statement in the petition also that how was this letter delivered and when. Now, in this,
what is your stand? You did not receive this letter.
No, I received it subsequent. They could not have written this letter on 5th of January. But it was responded to. Kindly come to page 106.
106?
Yes.
Yes.
This letter, again, I would say, my lord, that strictly this letter of 5th of January was sent to my client by email on 7th of February at 8:30 p.m. On a Friday at 8:30 p.m., the letter was sent through email. হ্যাঁ ঠিক আছে ওটা তো দেখিয়ে দিলাম
Yes.
Now kindly come back to the petition once again. Okay. Yes. They have not said that this letter was sent by email.
But this 106
yes
was produced by you.
No, I am producing it here, my lord. I shall be very candid.
But this was not
I did
produced
not get
earlier.
opportunity. No, it was expertise.
Yes.
Expertise ad interim order, I did not get opportunity. No, I was only on the point that, my lord, when they say that 5th of January letter was sent, they do not say how it was sent.
So this was not because this was an ad interim order. There was no question of producing before the trial court.
I was not there.
Yes, in the appeal court. No, appeal court they obtained an order of
Yes,
injunction.
trial court they did not get.
Trial court refusal.
Trial court refusal.
Thereafter, appeal court they obtained.
Yes.
So thereafter you appeared, and you have challenged that order here.
Yes.
You have appeared before the appellate court.
I have appeared.
You have appeared before the appellate court.
Yes.
And you have challenged this.
I have
so this is the
challenged this
first
here.
opportunity you are getting to disclose your defense.
Document.
Yes.
Now kindly come back to page 161.
Yes.
Kindly come to page 161.
Yes.
Paragraph 6. Paragraph 5, they say 5th of January later, then paragraph 6. The respondent intentionally sat tight on such letter. Still, they do not say when it was received by me. The respondent intentionally sat tight on such letter, and on 10th of February 2025, that is after more than 1 month from the date of the letter sent by the petitioner, very craftily drafted.
Yes.
Very
that
craftily.
is what I was from the within the first bracket, starting from that is wordings have been chosen very carefully.
Very carefully. Had sent a reply to the said letter of the petitioner. In the said reply letter, the respondent clandestinely refused to reschedule the petitioner's matches of the said championship on the pretext of prior commitment made by the respondent to its stakeholders. Kindly come to page 203.
203.
Yes. I showed your lordship 202, their letter.
This is your reply.
Yes.
Do you have a better copy of this? Anywhere annexed? Anywhere annexed?
I know. I said, my lord, to keep a legible copy.
No, I think here you must have annexed.
Oh, you have no space to.
Yes, Mr. Mitchell, you can place that. Let me see.
No, it's difficult for me also to place. আমি তো বলে দিয়েছিলাম কপি রাখার জন্য।
So Mukherjee, do you have a better copy of this? No.
May I read it out, man?
Yes, yes.
May I try to read it out?
Yes.
To so and so, dear Mr. So and so, you had requested to reschedule your match with East Bengal FC on 13th February 2025.
Yes.
Citing reason that you have commitment I2 and RFDL during the same period. May I hand over, my lord?
You have a better copy, Mr. Mitro. You can place that. Thereafter, I can.
Lordship will kindly look into, my lord. I am, my lord, trying to. এত লাফিয়ে বেড়াও তোমরা তোমাদের একটা I told you. You are scheduled to play, second paragraph, man.
Yes.
You are scheduled to play your I-League 2 match. No, I-League home match on 16th February 2025 and your RFDL match on 14th February 2025. However, as per our CMA's record, we can see that while the majority of your CFL squad is also registered in the I-League 2, there are only 2 players who are registered in both your CFL league and RFDL squad, namely so and so and so and so. Out of the 15 matches your team has played in CFL, so and so has made 2 appearances, totaling 37 minutes.
Basically, you have rejected their prayer.
No,
Citing reasons.
not only that.
Citing reasons.
RFDL match, Reliance match was rescheduled. পর ভাই আমি পড়তে পারছি না।
Mr. Mittu, you can take this.
Hey, Mel, I'm sorry. আসতে পারে তিরিং
Yes.
করে নাচছে। Okay. Out of the 15 matches your team has played in CFL, so and so has made 2 appearances totaling 37 minutes, whereas so and so has not made a single appearance as of now. So it is sufficient to conclude that your CFL, I-League 2 squad and RFDL squad are 2 completely different teams, and there should not be a problem to play your CFL match on 13th February 2025. It is ideal to have a gap of at least 2 days between 2 matches, which we at IFL have followed throughout the CFL season, but it is not mandatory as per norms. From your experience at I-League 3 organized by AIFF, you have played matches every alternate day, that is on 7th September, 9th September and 11th September, 3 matches in 5 days. And then again 30th September 2024, 2nd October, 4th October and 6th October, 4 matches in 7 days, including the final of I-League 3. The same can be applied for various national level tournaments, including the Santosh Trophy and national games. It is advisable to have a gap of at least 2 days between 2 matches which you are getting, as your senior team is scheduled to play CFL on 13th February and then I-League 2 on 16th February. A gap that is universally accepted throughout the world. We have already postponed the league for providing you the necessary support to ensure your best performance in the national level as the representative from our state. However, due to our prior commitment to our stakeholders, it is not possible to postpone CFL any further. You are advised to field your team on 13th February. This is the letter. Then kindly come back to their ballot, the petition. I was ballot at page 161, paragraph 6. Kindly come to paragraph 7. The petitioner, with a letter dated 11th February 2025, had sent a befitting reply to the respondent's letter dated 10th February 2025, wherein the petitioner categorically distinguished all the points raised by the respondent in their letter dated 10th February 2025. In the said letter dated 11th February 2025, the petitioner requested the respondent to once again reschedule the petitioner's matches dated 13th February 2025 and 18th February 2025, as the petitioner will not be in a position to field the competitive squad on the same day, and that shall give an unfair edge to the opponent. The petitioner further issued another letter on 12th February, wherein the petitioner informed the respondent that the petitioner will not be able to participate in the Calcutta Football League match scheduled for 13th February 2025. The petitioner urged in the said letter that as minimum required 24 hours window to practice, train and prepare for the matches was not provided, the petitioner cannot participate in the said match of the championship. Then kindly come to the next paragraph. The respondent, with a letter dated 12th February 2025, informed the petitioner that they will not reschedule the 13th February 2025 match Rather, they are trying to get the petitioner's match of Reliance Football Development League scheduled on 14th February on another date. Later on the same date, that is on 12th February 2025, in the evening, the respondent informed the petitioner that they will not be able to reschedule the 13th February match of the said championship. Rather, the petitioner's match in RFDL has been postponed. Kindly come to my lord, page 207. First line. The fixture for tomorrow's match was provided to you well in advance on 20th January 2025. Then, my lord, kindly come to page 209. They have received this. Their averment is that they have received this. Paragraph 8.
This document they have disclosed.
Yes, they have disclosed.
No, but I'm asking you, what is the mode of? Have they disclosed when they have received this letter?
No, they possibly received. Kindly come back to paragraph.
I'm not on the issue of receiving or not receiving. The date when they received. Has they disclosed anywhere when
they do not
received?
say that they received it, my lord, on or after 13th. They do not say that. The match was on 13th.
Yes.
They do not say that they received it after the match.
Yes.
Paragraph 8 does not say that.
Yes.
Now, this was first letter of 12th February. Kindly come to the second letter of 12th February. Page 209.
That the other match has been rescheduled.
Yes. So their grievance was that
postponed
matches on 2 consecutive dates.
That was their only grievance.
That was their only grievance. That was taken care of. 13th February and, my lord, on the next day, Reliance. So they don't get time to, my lord,
prepare
themselves, prepare, practice, blah, blah, blah. Now, 13th and 18th. Now,
yes.
So the entire, in my respectful submission, I submitted before your lordship that, my lord, the plaintiff, my lord, a reading of the plaintiff would show that the plaintiff does not have any cause of action. Their allegation, as I said, their allegation was that 2 consecutive matches on 3 days, 13th, 14th and 18th, they will not have sufficient time. They will not get 24 hours window. That is their letter. Now, 14th match was postponed. Nothing remains.
Yes.
The rest of the plaintiff, my lord, that petition there, it ends practically. Then page 164, that in the aforesaid facts and circumstances,
these are the reliefs claimed.
These are the reliefs claimed. Then kindly come to ground for injunction. Kindly come to page 165.
Yes.
The petitioner has a strong prima facie case in its favor. The aforesaid interim orders are necessary to protect the right and interest of the petitioner. This is a fit case for passing ex parte orders. The petitioners apprehend that if notice of the application is given to the respondent, it will act immediately in furtherance of its sinister plan and shall make the instant proceeding infructuous. Delay in giving notice will also defeat. Delay in giving notice.
East Bengal Club is also a party.
No. And paragraph 14, page 167, has been verified as submission.
Paragraph 14.
13, 14, both.
This affirmation in the affidavit, these paragraphs, if it is to be looked into, none of the
My lord,
proceedings.
it reminds me, my lord, before Mr. Pratap Chatterjee, I was instructing him, I was very agitated. I showed him that, look here, how the petition has been, or the plaint has been verified. Looked at me, that is your best point. Said, it cannot be looked into. No, don't take this point ever. Now, be that as it may. These are the facts. What I am trying to say is, your lordship has seen paragraph 13 and 14. No ground, my lord, for stopping, my lord, the declaration. They did not, they came up before the court much subsequently. Now, you come in. Okay. তোকে যে ইনস্ট্রাকশন দিচ্ছে সে কি? Now kindly come.
The Chatterjee is disturbing you, Mr. Mitra.
Yes, he is continuously saying that I am, my lord, appearing for East Bengal. That is what he has to say.
এত বিশাল মোহনবাগান
আমি কোথায়, আমি কোনোদিন দেখেছিস কোথাও কমেন্ট করতে?
না, আমি তো জানি না।
Yes.
Now kindly come to the trial court order, my lord, page 30. Kindly come to page 31.
But the other way around. I have told the East Bengal supporters that you all had to take a Mohan Bagani to get yourself declared as a champion.
Kindly come to page 31. But kindly come to, my lord, page 34, because, my lord, before that, my lord, technical points have been
recorded. Yes.
Kindly come to page 34, factual matrix.
Yes. I think it starts from 36.
35, my lord.
35, those three tests have been,
Yes.
Those facts have been narrated.
And the letters have been looked into.
Yes.
Then
three
36.
tests, yes.
Then 36, yes.
The primary purpose.
Absolutely. Primary purpose for granting interim relief is to evolve a workable.
But you can skip that paragraph.
Yes.
Next paragraph. According to the plaintiff.
But kindly come to, my lord. Yes, according to the plaintiff. Then kindly come to the next page, my lord. The letter is set out here, scheduled to play page 37. The letter which I read out.
Yes.
Then kindly come to page 38. Top.
Yes.
It is apparent that the plaintiff has participated on alternate days on such and such, such and such, such and such days, and then again on such and such days. It is pellucid to this court that a gap of at least 2 days between two matches is an ideal proposition and not a settled rule and regulation for the Indian Football Association. That apart, on being asked, the plaintiff has failed to produce rules and regulations pertaining to the Indian Football Association. Reasonability is a sine qua non for any judicial order. It is also necessary to mention that the petitioner is leveling an allegation against the association that they are not providing a level playing ground equally to them. Even if by stretching the boundary of imagination, this court considers that the defendants are perpetuating injustice by not providing a level playing field equally and giving undue advantage to other clubs, then this court cannot give any relief to the plaintiff, as negative equality cannot be envisaged by the Indian Constitution, and my view is getting authoritative support from the decision in such and such. The twofold object of this application is that on account of participating in other tournaments, the plaintiff is unable to participate in the tournament, and the defendants are giving undue advantage to other clubs. Therefore, the plaintiff is entitled to get an injunction. The court cannot become a vehicle of injustice. It is also apparent that the plaintiff is taking a chance by approaching this court as they are knocking on the door for the event that happened on 13th February 2025. The plaintiff has also mentioned that owing to a tight fixture, the plaintiff is not in a position to vie with other teams. It is also limpid that the plaintiff had participated in another championship, and that is one of the main reasons for which the plaintiff is seeking injunction. It is also pertinent to mention that gap of 48 hours is not a mandatory rule. This court cannot restrain the defendant from continuing the tournament, as a plaintiff owing to tight fixture cannot vie with other teams. In the absence of best available team, plaintiff has failed to demonstrate prima facie case. It also emerges that no irreparable injury will be caused to the plaintiff if no injunction is granted. There is nothing that manifests the balance of convenience must be in favor of granting an injunction. Now, this was the order.
What happened to the tournament?
The match was valid. The point was given to the other side valid.
So the tournament has ended.
Yes, yes.
What was the last
result has been valid upheld.
Yes. What was the last match? Because this order was passed on 17th of February.
That's true.
And what was the prayer?
18th was the last match.
No, 18th to where? I-League 2. Well, the league is complete, I understand, my lord. The results cannot be declared. Yes.
No, so there was a permanent injunction restraining the defendants from continuing with the match scheduled on 18th of February. That was done.
Yes. Now kindly come to the order impugned, my lord, page 27.
Mr. Mukherjee, certified copies have been filed. Yes.
You can see from the computer itself, our number has been given.
You have filed in the department.
Now we have everything we have to file in the computer section. Now the system has been changed. You also can see in the monitor minute, number is given.
All right. Yes. Yes, Mr. Mitro.
Now kindly come to the order impugned. Order number 2 dated 19th February. Kindly come to the last page 27.
Page 27, yes.
Last paragraph.
On perusal.
On perusal of the materials and copy of documents on record, and after learned advocate for the appellant prima facie, it appears that the appellant has not been provided with appropriate opportunity to play the game as per law. Which may cause irreparable loss and injury. Order of 19th February. By then the match was long over. May cause irreparable loss and injury in their fundamental right to participate in the match, and moreover, it also prima facie appears that in spite of intimating the matter to the authorities, no reply has yet been.
Not the correct recording of facts.
No. I was proceeding on the basis of the plaintiff petition. The charge court is entitled to, of course. He possesses.
Considering the urgency.
No, I'm not on that. I'm not on that. But kindly, two things. Game as per law. First page, last line. The appellant has not been provided with appropriate
twofold considerations which weighed in the minds of the first appellate court is, one is, as per the law, it was not done. Second is, though they have paid for, no reply given to that.
Now,
these were the twofold.
First, as per law.
As per law is
as
one.
Per law,
other thing
the trial court says that in spite of repeated requests, my lord, they did not produce the rules and regulations. So it cannot be said that it was as per law. Recording, your lordship has seen, my lord, the recording of the learned single judge.
Here it also does not record any rule in that regard.
No, no. And then, no reply. No reply has yet been given in support of the same.
Yes.
And my lord, lordship is aware, my lord, I don't think that judgments are required, my lord. There are judgments that unless the order is perverse, the my lord, first appellate court does not interfere.
Which if you want, please cite, because they might cite some decisions also.
No, maybe. But that is, my lord, the law which we understand, that merely, and this is allowing the appeal. This is allowing the appeal. Hence, it is ordered that the prayer for an order of ad interim injunction is allowed in
this
favor.
is in aid of the final relief. There are two things. This is in aid of the final relief.
The respondents are hereby restrained from declaring and announcing the...
One is granting final relief, another is in aid of the final relief.
But without hearing.
That is a different thing.
Without hearing.
That is a different thing. But can it be said that it amounts to granting the final relief, or it is in aid of the final relief? Because these are the two distinctions. Final relief at the ad interim stage cannot be granted.
But the ad interim order refusal.
But if it is in aid of the final relief, can it not be?
Yes, kindly.
If the suffering is proved to such an extent, if that is not protected, then
Suit is decreed. Suit is really decreed.
Why?
Kindly come to my lord.
What was the prayers?
Kindly, I was
plained.
Yes, kindly come to my
Prayers
lord.
in the plained.
165.
150?
65.
165.
The portion which have been set out.
No, 65 is the temporary injunction.
No, before that, man.
Oh, 64,
164.
64.
164. Petitioner prayer. No, plaintiff prayer later. Kindly see prayer B.
Yes. But it's a permanent injunction. This is an ad interim. That happens in all temporary injunctions.
When I mentioned
suit,
when I mentioned the matter, my lord, before your lordship, my lord, I submitted before your lordship that I will try to demonstrate that, my lord, the plaintiff did not have any cause of action.
Yes.
Their allegation, only allegation. I have shown your lordship the, my lord, petition up to the prayer of the plaintiff. Only allegation was that fair opportunity was not being granted by fixing matches on 2 consecutive dates. And from
the other way, their prayer for rescheduling that match, no reply to that prayer was given.
But my lord, the second match was rescheduled, postponed. So the prayer was granted.
In the other form.
In other form, yes. They did not want to play 13th match because they have a match on 14th and then on 18th. Now 14th match was, my lord, removed.
So their main problem now gets addressed.
Well,
anything more, Mr. Mitro?
No, as I submitted before your lordship, my lord, that he did not make any whisper or very craftily drafted, my lord, petition of the plaintiff does not say when this letter of 5th January was, my lord, given. And when I say that the fixture was published on 20th of January, they respond to it.
That you cannot show anything.
No, their letter.
20th of January.
Yes, kindly come to their letter. I'm sorry.
Please show me that it was fixed on 20th of January.
Kindly come to page 207.
No, this is your statement. Was provided to you well in advance on 20th of January.
Yes. They do not
But
deny
they,
this.
they replied to this 12th of February.
Yes.
Did they deny this fact
No.
in that reply?
No. No.
Have you checked up that this has not been denied?
Yes, kindly come to page
That is the reply to this letter.
210.
210.
Yes.
No denial.
Kindly have a look at the letter at 201, 210.
210, yes. Which portion?
First paragraph.
This is to the reference of your letter dated 12th February. Regarding the match today, we have time and again cleared.
No, Mr. Mukherjee, I want to know, in their letter of 12th of February at page 207,
Lordship.
kindly come to the first sentence of
Yes.
that effective first paragraph.
Yes.
The fixture for tomorrow's match was provided to you well in advance on 20th of January 2025.
Lordship.
So, is there any denial from your end with regard to this statement of fact? In reply to this letter?
Lord, this is not replied to in 210. This letter,
yes,
first line of second paragraph.
First line, second paragraph, yes. Show me that you have denied that this was not fixed on 20th of January.
Second paragraph.
Mr. Mukherjee, only my query to you is...
I understand what your lordship is saying.
Here it has been stated, their stand is that...
On 20th January, you knew about it.
Yes. We informed you about
yes.
this fixture on 20th of that day's match, 13th. 13th match. So, have you disputed this in the reply letter to this? Show me that portion.
Now, Lord, your lordship will kindly come to Lord the letter of reply that is at page 210.
Yes.
Regarding the match today, we have time. This is with reference to the letter I answer.
Yes, yes.
Regarding the match today, we have time and again cleared that we are not in a position to play it. Also, the communication regarding the changes that have been made were informed to us within the time frame of 24 hours of the scheduled match. This ground cannot be overruled citing any other reason whatsoever.
No.
But that is not an answer to not their...
Mr. Mukherjee, this could not have been.
Lordship.
Because 24 hours of 13th of February is 12th of February.
Because on 12th...
But prior to that, they have informed this. So, it's not that this change was made on 12th. On 12th, they said that we are not postponing this match.
But your lordship's query that you knew about it on 20th.
Of this fixture of 13th of these two clubs.
But that I'll just check. That I'll check.
And from any documents which have been disclosed. Mr. Mukherjee, it has to be from the documents which
so that is not
disclosed.
Yes. But what document that we had disclosed before the court? But there are multiple documents that my learned friend.
I did not at the beginning said that he has annexed, but he has not relied upon that. This 20th of January, though he said that your letter could not have been issued on 5th of January because they but he has not relied upon that. He has not, oh, he has cursorily mentioned that, but he's not really pressing on that document. So his endeavor is with regard to page 207. It's not in dispute that you have received this, and this is the.
No, I have replied that. I have replied.
And you have disclosed this document. It's not that Mr. Mitro is disclosing this.
হ্যাঁ দিয়েছি তো আমি জানি
তারপর তো 20th তো জানিয়েছিল,
হ্যাঁ।
তারপরে তো আমি রিকোয়েস্ট করেছি। There is no dispute on that.
The 20th I knew about.
I too knew about it.
So he
And thereafter, Lord, that the
could not have
communications
written the letter on 5th of January. That is what I say. Now, one my lord,
anything more, Mr.
one division bench judgment, my lord, or a very recent judgment. One paragraph, my lord.
Correct. It's 5th of January, or 5th of February.
I know. Now, what a judge says,
unreported judgment, my lord, kindly come to
give a copy to them.
I have no dispute.
Yes. For what proposition?
Kindly come to page 5, paragraph 13.
Page 5, paragraph 13.
7 February চিঠিটা কোথায় আছে?
এখানে অ্যালেক্স করেনি ওরা।
আমাদের কাছে আছে সেটা?
7th 10 তারিখে দেখুন রিপ্লাই করলো, 7th এর চিঠি 7 তারিখে।
7 তারিখে চিঠিটা।
So if two views are possible, it should not be substituted.
If two views are possible, according to me, my lord, there was no second view possible here. I am in a better footing.
Yes.
My lord, those are my.
Yes.
But we'll come back on the next day, Lord Mr. Mukherjee.
Page 106 এ আমাদের 7 তারিখের ইমেলটা রয়েছে।
But at page 106, Lord, there is an email, Lord, which says about and protest about, Lord, that fixture which we had received on page 106, 106.
106 type which it 7.
Yes, Mr. Mukherjee. Yes.
There
is a protest about this fixture. There are two aspects.
No, this is, my lord.
There is no dispute with regard to page 106.
Lord.
What Mr. Mitro's endeavor is that in page 106, this is the document which was sent through electronic mail.
Yes.
And it was sent on 7th of February 2000. So these two things are not in dispute.
Lordship.
So now, this, according to Mr. Mitro, this letter could not have been dated on 5th of January 2005. Because now he's trying to rely upon page 207 to show that the fixture was only fixed on 20th of January.
That was.
That is his submission.
I understand that.
Date of the letter.
It cannot be 5th January. It can be only after the
prior to 20th of. And this service. So this letter of 5th of January, this letter of 5th of January was only sent by electronic mail, Mr. Mukherjee. That is your stand?
Lordship.
By no other mode.
Lordship.
By no other mode. So it's
a typographical error about the month. It should have been read, Lord, as February instead of January.
Then Mr. Mukherjee, this comes that first bracket portion of that paragraph. Please come to that paragraph now. Yes, Mr. Mitro, which paragraph within that bracket?
Kindly give me a step. না 203. Oh, yes, paragraph 6, page 161.
Yes. Mr. Mukherjee, that is more than 1 month from the date of the letter sent by the petitioner. If it was on 5th of February, 10th of February could not have been 1 month. If that submission is accepted, by mistake January instead of February, then it could not have been 1 month. That is why
that is
instruction.
That is.
But that 1 month or 4 days may not matter.
It doesn't, but it
will not matter to that extent whether it's 1 month or 3 or 4 days. But Mr. Mitro was trying to emphasize that it was a clever drafting.
Yes, Lord, that I understand.
Mr. Chatterjee, I am certain.
So it was at his instruction It was at the Mr. Chatterjee has settled this. This insertion was as
But I didn't drop the plaint.
No.
The plaint came
the Mitro says you have settled the plaint.
Now, East Bengal will obviously target me. He's now an East Bengal supporter. He will obviously target me.
Yes, Mr. Mukherjee, when?
Lord, we'll take an instruction on the point that your lordship has.
May I only submit this, my lord, a close date.
And no, there's another, my lord, a prayer.
A close date, my lord, so that.
Yes, that is why, Mr. Mukherjee, I will forget everything. What is the convenient date?
Gopal date.
Because everything will get out of my mind.
Lords, but other thing, Lord, that they have used, Lord, certain documents. Lord, may we come up with a short evidence?
Rely upon any. It's only the injunction application. He has not even placed your plaint.
Lord,
He has only placed the paragraph from the
That is
injunction.
why I did not.
He has only placed the injunction application and the documents which were part of your injunction application.
only those. Only those. Yes.
So I will not allow Mr. Mitra to rely upon any other document.
Very well.
I have.
So he will restrict his submission only to those.
My lord, in conference, the first thing I told that I will not rely on any of these documents. That is the first thing I told.
8th May.
8 May অনেক দেরি হয়ে যাবে।
8th May.
তাড়াতাড়ি কর, তাড়াতাড়ি।
বাংলার উপরে উপরে
Next week, any day.
Kindly see.
মানে 2 সপ্তাহ হয়ে যাবে।
ভালো হয়ে আছে ক্যালেন্ডার। ক্যালেন্ডারটা লাল।
জিতবে না কেন প্রস্তুত আছে?
খেলে জিততে বলো না টিমকে। আমাদের
পয়েন্ট পেয়ে জিত।
হ্যাঁ। খেলে জিততে বলো না তোমার টিমকে। আমার টিমের মতন।
আচ্ছা, ওই জন্য কি ওটা কি অ্যাডিশনাল কনসিডারেশন?
একটা জিনিস পেয়ে গেছো না? জানতামও না।
But I'm sorry, Lord, to hold it.
Kindly fix a time.
Mr. Mitra Lanet
They have entered appearance, 4 dates have gone. They are not even filed a written objection.
Naturally. That's
Whether
nothing
or not
unusual.
the only question is whether or not the interim order will survive or not.
That's nothing
But
unusual.
eventually, they have to go back. 330. 330. 330.
3:30.
3:30, don't, kindly.
3 p.m.
Very good.
See, what submission of Mr. Mukherjee?
हाँ क्यों सुन हाँ
Agreed.
yes हाँ डाकुन ना oh it's that matter it also cannot conclude
I'll quickly show your lordship a little bit, Lord, and try and conclude it today itself. Within that 4-5 minutes, if I can.
all right
If I can.
if you can conclude please conclude today
If I can.
you can take some more time also no difficulty on that
No, I think
yes
beyond 4:30.
yes
4:30 beyond minutes, obviously,
yes internal arrangement I have not heard anything but you can proceed
that was meant for your lordship.
no I have not heard anything but you can yes
Lord, yesterday I was showing your lordship, Lord, with respect to rather. Lord, your lordship yesterday wanted to, Lord, see the plaint that we had filed, Lord, before the trial court of specific performance. That your lordship will, Lord, Urmila is Urmila ke dhoka.
It has been annexed.
Yes, Lord. Kindly have a look at page 136.
136, yes.
My lord wanted to see that.
Yes.
136. Acha. Decline korte?
Yes.
Sir, রেগে গেল তোর উপরে? And below your lordship sees below the first thing is the cause title once.
Yes.
Below which your lordship will find first at 137. Sees the Kiatala property, my lord, given Aniruddha Banerjee, plaintiff 6C Kiatala Road. 137. And then turns to my lord 142.
Yes, what happened?
Nah, just the papers have fallen. 142. My lord, your lordship turns to, this is with respect to that. Kindly have a look at the schedule, for which, my lord, your lordship has to go back to the second volume.
Yes, so it was for specific performance of the agreement dated 26th of July.
That's the condition.
And the settlement agreement dated 28th of September.
Absolutely.
By releasing and of handing over the possession.
Absolutely. Now,
what you wanted that possession is to be handed over by virtue of that.
Now what happens is, they my lord, file their claim, statement of claim, my lord, before the arbitration. That becomes really important. Kindly have a, because that will be the crux of my argument. Mr. Malloy. Lordship has a supplementary affidavit, my lord.
You have given them a copy.
কালকে দেওয়ার কথা ছিল।
Yes, supplementary.
Kindly have a look at page 37.
37, yes.
My lord, here your lordship will find.
I must just point out that this was not before the trial court. These documents. I just pointed out.
They cannot be. The problem is, my lord, because I am coming from a section 14 order, I cannot be before the trial court.
Yes.
Kindly cease to 37, my lord. Your lordship will find the claimant's details are given. Turns over, my lord. Your lordship will find the details of the respondent is given. That's Shomuk, Aniruddha Banerjee. Case of the claimant in detail, I'm not troubling your lordship's lordship with much on that, but all of this is stated.
Now, Mr. Chatterjee, only one thing.
My lord.
You are against an order refusing to pass an injunction.
Injunction. I am saying, my lord, on the basis of whatever is there.
So if this were not before the, I appreciate that you have challenged an order under section 14, but these documents, if those were not part
just
before the tribunal, can you rely upon?
Before
you are not party in section 14.
Yes,
but when you have challenged the documents which you relied upon in before the tribunal, that only can be looked into. Whether any other document can be looked into.
No, kindly have a look at my application before the tribunal. Tribunal application about karo. It's there. Huh?
This were part.
I'm pretty sure. Kindly have a look at 230. No, statements would be there. If I'm not, my lord, mistaken. Page
No,
230.
even if statements were there, you have not produced these documents. The tribunal did not have the occasion to consider this, Mr. Chatterjee. You may have stated that they have filed an arbitration application. This was the claim. But if you have not produced those documents before the tribunal, so this only, this court has to consider whether on the basis of the materials that were before the tribunal, whether the tribunal was right in not granting an interim relief.
Very well. Very well. I don't have a problem with that also. Very well. Then I will come to, on the basis of the documents which are there before the tribunal, I am entitled to an injunction. Then kindly comes to that. Lordship for the moment doesn't look into, my lord, what is there.
Yes.
Kindly turns to 232.
232, yes.
There is the section 17(1) application first, then the sanction letter, then the copies of the loan agreement, copy of the purported notice under 13(4), orders will not pass by the tribunal.
Where from you are listening this?
232, my lord?
Yes, 230. Oh, 232. Sorry.
232.
Oh, these are the annexures.
Annexures.
Yes.
The tripartite agreements were all
These
there.
are the agreements which were placed
Exactly. I placed yesterday, and also the license agreement is there. No problem on that. So my right.
So copy of the plaint was there.
Copy of the plaint was there.
Number 15.
Number 15.
But this arbitration was not there.
This arbitration, for some reason, I bought, which is the most তার জন্য সব থেকে ইম্পর্টেন্ট জিনিসটাই দিতে ভুলে গেল, চিৎকার করতে হবে। 140 ছিল, 233, my lord, if I am not mistaken.
This refers to plaint, but
it was there. It was
so
there.
plaint was there. Yes.
Come back tomorrow. Come back tomorrow.
Why?
For finishing my argument.
Strategy, how much? You said 4-5 minutes.
No. That's to start. That's why. I'll take a little bit of time. Because now, my lord, what is happening is, my lord, since I moved this application, if I go back, my lord, without an order, my lord, that will influence the tribe.
That will
influence the tribe. And that's why, my lord, I want to, my lord, place my entire cards before your lordship.
I can protect you to that extent. I can protect you to that extent.
Transfer an injunction, I don't have a problem.
That is a different thing altogether. If you say that since you have come here,
That protection, I know what protection, that protection doesn't work.
yes, but
Never worked.
it has
Now, if they had not filed a writ petition, my lord, before this honorable court, I would have still taken a chance. They have filed a writ petition asking the police to go and throw me out. That I can't.
that you can contest, Mr. Chatterjee.
No, I cannot. No, I don't take a risk. I risk there. I can't take a risk.
That petition you can contest. That is a different.
That's a
proceeding
different aspect.
altogether.
No, that's an execution petition.
Petition.
That's an execution petition.
That's a, no, it's not an
That's an execution petition saying I have
That's
an.
in effect an execution
Well,
petition
it is
because you are trying to execute the order passed under section 14
Definitely.
through police cell
is pending.
and through police cell.
He has not been, well, may I just say 1 minute, my lord. I find that the
Sir, I only one thing. Good, bad, indifferent, and order passed under section 14 has been challenged before the tribunal, my lord. So whatever may be the result, ultimate result,
my lord,
that may remain, that may be set aside.
my lord.
So once there is a challenge to the parent order under section 14, if you are taking steps for implementing or executing that order, what remains with this proceedings before the tribunal?
My lord, may I just say this, my lord? Here is a, my lord, the proceeding is such, my lord. If it is found ultimately, my lord, that it is not correct, DRT can always reverse it.
Which proceeding? No, Mr.
My lord,
That is
I'm going to
the other way around.
I'm going to the extreme, my lord. I'm going to the extreme case. If the matter is heard out, if there is done anything,
Let
my
us
lord,
see. There are two things.
My
One
lord.
is, this is the first forum which is challenging because he did not get any opportunity when the order passed, when the order under section 14 was passed. Rightly, you may say that he is not entitled to. I'm not on that. But he has a right to challenge that.
Yes.
And he has availed of his right. He has approached a forum.
And he has approached a forum where the forum.
So
is
now, during pendency of the forum, now you are trying
That
to.
is why I say, my lord.
You are trying to execute that order.
That is why I'm here. My lord, may I now? Now, I absolutely, my lord, I'm on that now. My lord, that is why, my lord, the statute has been prepared in that fashion. Then, my lord, they have to secure. And that is why DRT. They have to put in the entire money. That is why DRT, my lord. My lord, these are galore judgments which say this. That is why your lordships have.
No, there are two things. One is your objection to the mentality of 227. One is your objection with regard to the mentality of 227 in view of the provision of appeal. That is one aspect.
No, not only that, my lord. Even for that, my lord, even if, let us say, my lord, the order is wrong of the DRT. If he has to go to DRT and get a status quo, my lord,
He has to secure.
is it?
No. I'm not on that. I'm
No,
not
no,
on that.
please.
Now, whether
No, please. No,
what amount he will have to secure or not, that is the thing. I'm not on that. That objection you can take.
But then if he gets a stay on that, obviously I will not proceed. Let him secure the entire amount. Let him give the entire money.
What entire money? About 18 crores.
Come on. Let's come to terms.
Of course, come to terms. I'm not running away.
What are we on?
That is.
There is due.
No, you can
You
raise
release
an
the
objection
property.
with regard to the mentality. I will hear you on that. It's not that I am shutting you out from
I understand.
on the maintainability. But if in the meantime you
That is-
execute that, let us assume that I
sorry.
accept your submission that this revision application is not maintainable.
Madam.
I relegate Mr. Chatterjee to the appellate forum
Madam.
after hearing your objection. But in the meantime, you execute that decree.
That is why
You
it is
execute that
provided.
order. What will happen?
That
That is the only thing which is troubling me.
Malad, may I kindly, Malad? That is why 17 is the Malad 17 provides for it. That it will 34 provides for it.
Section
17.3. 17.3b restore the possession.
Possession of what?
No, please.
If I take it,
whom?
To you.
From whom it is
Mr. Rai, that is already there.
Yeah,
Mr. Rai, you know, 144 CPC is also there. So even then, the order of stay of execution are being passed because you know that decision of swinging pendulum. Only for that. So if not, then again reversing, you know it's difficult.
According from your lordship would mean that if he files a application, that tantamount to a stay.
No. I'm not saying that.
That would happen.
I'm not saying that for a moment that will amount to stay of that.
No, it
But-
happens now, my lord. Let us say, my lord, today, my lord, they don't, my lord, DRT, we know what, they will have to move the DRT.
Yes.
My lord, I am doing a matter, my lord. For 2 years, my lord, nothing is happening. Now the point is, my lord, there is no stay. Now, Dharav na Baba. It has been, my lord, I'm giving the both sides of the coin, my lord. I understand Mr. Chatterjee's point. I also understand my point, my lord. Now today, my lord, I am out of pocket, and my lord, there is no stay, no injunction granted. Now, my lord, if he comes before your lordship and says that since I have filed an application before your lordship, my lord, on 227, they will not take any steps. My lord, kindly situation. My lord, there is no law behind this. What is it that we are saying that again it will go, it will come back? My lord, that is why we are saying that no, you hold your horses. Now the point is, my lord, today I have, as a matter of fact, today we have already served them with the affidavit in opposition.
Before the tribunal.
Yes, yes.
Yes, yes.
My lord, we are late by 7 days. They have 7 days to put in their reply. That is, yes, I'm saying.
ভালো তো সেটা I'm saying so obviate everything. He's filed an opposition, gives me 3 days time to file my reply, prepones the date back. Do not ask them not to implement it in the one.
Why that? Well, that means your
But
lordship.
nothing happened. Then what remains if the
What is the date? What is the
Let
date?
him ask,
What is the date fixed before the tribunal?
tomorrow? And they are late by 7 days. They are taking advantage of their own law. I am saying give me 3 days.
Okay, my lord, kindly decide the question of maintenance. Let him finish and then I will.
We come back tomorrow then.
How much time is Chatterjee?
Sir, it's 4:45.
Yes. How much time it will take? Mr. Chatterjee, how much time it will take?
No, I will not take more than 10 to 15 minutes.
Can complete it today.
But but that doesn't. I'll come back tomorrow.
Why?
ওর বলেছে আমার হবে না তো ওর হবে।
No, no, no. Yours is secured.
পাচ্ছি না, সত্যি আর পাচ্ছি না। Come back.
Mr. Chatterjee was saying I cannot.
My lord, may I say this? Your lordship doesn't know, my lord, what happened. We are really aging now.
Yes, my
I'm
lord.
telling your lordship.
Mr. Chatterjee, don't say so.
I'm telling your lordship.
My lord, the heat is something which is very difficult.
From going from courtroom number 22 to my lord, courtroom number 39.
That is really.
My lord, I've done it thrice today.
I also went to the NCLT, my lord.
And they have to go to
complete and
NCLT.
complete. From my lord, we have an original side bench, my lord.
I never
37.
I never complain about this because I have chosen my profession. I have to do it. But now I'm feeling what Mr. Rai Chaudhary used to say when he was 80. My lord, it's impossible.
Choosing your profession, man.
But can you not? I think there was a proposal. One type of matters, one type of matters.
They've done it for the criminals. They've done it for the criminals. They've done it for the money man.
They haven't.
No, don't say.
No.
Use something after the first word which you have used.
My lord, why not? The criminals are getting their justice from one court only. No, not us, my lord. One of the commercial court is in that court number 37.
That is a designated, so that cannot be changed.
Kindly.
That cannot be changed.
Now the second bench, the non-commercial is in court 23.
23.
The opposite. If I do it twice,
The judges don't want to leave their courts. They are comfortable in those courts.
Now we are changing. What are you saying?
My lord, in one of
700 কত থেকে সরেছে? 700 কত থেকে সরেছে?
Court number 9 has become the execution court. Now, my lord, kindly appreciates we are 50. I am 50, is 48, I believe. The others also, there are seniors in the profession, my lord. It's very difficult.
But that
Very
is
difficult.
really a problem.
And
That
I didn't complain till yesterday. After yesterday, my lord, it's very sapping outside.
yes,
It's draining you.
Last 3 days.
Literally, I'm saying, well, I never say this, but literally, পাচ্ছি না.
that is why I was astonished. You are saying that
I'm really পাচ্ছি
The
না.
heat is
একদম পাচ্ছি না.
enormous, my lord.
no, that is for the last 2 or 3
And
days.
my lord, if you once
I
enter
think
the
2 or 3 days before the evenings were pleasant.
Yes.
Yes.
Today, even now, even
But
that
from yesterday, the evenings are also.
completely.
my lord, it's a lesser of the two evils. We decide. Do we take the elevator or we don't take the elevator?
Better is
If we take the elevator, it's crafted.
to avoid that
My lord, that is
during this.
Worst case scenario.
Yes, it's worse than the outside. It's better to use the
Staircase is
yes.
much better.
staircase and the